Next page. Chapter 11, International Protection of Human Rights, Summary. _ 11.1 Introduction. International human rights law operates at 3 levels: global, regional, and subregional. Each level has advantages and disadvantages. Key themes include universality versus socio-cultural specificity, extraterritorial human rights application, and global, regional, and sub-regional human rights systems. Focus on the African system and the relationship between international and national law, particularly in South Africa. _ 11.2 The rationale for and nature of international human rights law. Post-World War II, human rights internationalized, individual recognized as a subject of international law. Purpose of international human rights law. 1. Guiding framework, encourages states to align domestic laws with internationally recognized rights. 2. Safety net, allows international recourse if national remedies fail. 3. Independent oversight, ensures states uphold human rights. Subsidiarity principle, local remedies must be exhausted before international intervention. Sources of international human rights law. International treaties, binding upon ratification. Customary international law, binding regardless of consent, for example, prohibition of genocide, racial discrimination, slavery. Evolution of human rights categories. 1. First generation, civil and political rights. 2. Second generation, socio-economic rights. 3. Third generation, collective/solidarity rights. Obligations of states. Respect, refrain from interference, for example, no arbitrary evictions. Protect, prevent non-state actors from violating rights. Fulfill, allocate resources to ensure rights, for example, funding for elections, education. _ 11.3 The layers of international human rights law. Operates at 3 levels. 1. Global, United Nations. 2. Regional, continental human rights bodies. 3. Sub-regional, smaller regional organizations. Factors in choosing the appropriate forum. Jurisdiction, substantive, personal, territorial, and temporal jurisdiction. Normative framework, regional/sub-regional norms often more detailed and culturally relevant. Accessibility, sub-regional greater than global institutions in terms of reach and convenience. Effectiveness. UN enforcement is weak, no World Human Rights Court. Regional/sub-regional courts have more binding authority. Close regional ties may either strengthen or hinder enforcement, for example, SADC case on Zimbabwe land reform. Multiple pathways. Complaints must follow the hierarchy set by treaties. Some treaties, for example, African Commission, disallow cases previously settled by another international body. _ This summary condenses the first part of the chapter. Let me know if you need further details or additional sections. Next page. Here are detailed study notes summarizing the provided text. _ 11.4 The tension between universality and socio-cultural specificity. Universality of human rights, rooted in philosophy, religion, and the Universal Declaration of Human Rights, UDHR. Discrepancy in enjoyment of rights. Human rights versus human rights law. Human rights, ontological claims, inherent to all humans. Human rights law, legal guarantees codified in treaties, allowing accountability. Goal of international human rights law, convert human rights into legally enforceable rights. Global South resistance to expansion of human rights law. Argue human rights treaties reflect a Western perspective. Demand rights to align with socio-cultural contexts. Claim reasonable if it does not justify repression or deny dignity. Mechanisms to balance universality and cultural specificity. Principle of subsidiarity. National legal systems must domesticate international norms but remain subject to international oversight. Reservations in treaties. States can exclude provisions unless it undermines the treaty's purpose. Margin of appreciation. European system, allows states deference in social morality issues. Derogations and limitations, allowed in emergencies and societal interest, provided they are legal, justified, and proportionate. International oversight, treaty bodies monitor compliance with these mechanisms. _ 11.5 Extraterritorial application of human rights. Key question, do states' human rights obligations extend beyond their borders? Sources of obligation. Human rights treaties bind states to secure rights for individuals within their jurisdiction. Jurisdiction includes effective control over territory, individuals, or perpetrators. Distinction between rights obligations. Civil and political rights. States must respect rights, even extraterritorially. Socioeconomic rights. Fulfillment may require resource allocation, making extraterritorial obligations complex. European Court of Human Rights, ICTR, Precedents. Hassan v. United Kingdom, 2014. UK detained an Iraqi citizen without following the European Convention on Human Rights, ECHR, procedures. ICTR held that the UK had extraterritorial jurisdiction but no violation occurred due to compliance with the Fourth Geneva Convention. Economic globalization and socio-economic rights. 2012 Maastricht Principles clarify extraterritorial obligations. States must respect, protect, and fulfill socio-economic rights, including ensuring remedies. UN Special Rapporteur, 2014, concern over violations related to water and sanitation by transnational corporations and donors. Treaty body observations. UN Human Rights Committee urged Germany to ensure businesses comply with human rights when operating abroad. _ 11.6 The Global System for the Promotion and Protection of Human Rights. 11.6.1 The United Nations and its Human Rights Standards. UN Human Rights System. Charter-based mechanism, applies to all UN members. Treaty-based system, applies to states voluntarily accepting specific treaties. Universal Declaration of Human Rights, UDHR, 1948. Non-binding but carries moral and customary international law weight. Basis for human rights treaties and the Universal Periodic Review, UPR. Evolution of treaties. Cold War ideological divide led to two treaties in 1966. International Covenant on Civil and Political Rights, ICPR, immediately enforceable. International Covenant on Economic, Social and Cultural Rights, ICSCR, requires progressive realization. 2008, optional protocol to ICSCR allowed individual complaints, restoring indivisibility of rights. 11.6.2 The UN Charter-based Human Rights System. UN Commission on Human Rights, UNCR, before 2006. Criticized for bias and selectivity in country-specific mandates. Human Rights Council, HRC, 2006-present. Subsidiary of the UN General Assembly, GA. 47 rotating member states, elected for 3-year terms based on geographic distribution. Membership conditional on human rights records. Suspensions, Libya, 2011, for human rights violations. Withdrawals, U.S., 2018. Universal Periodic Review, UPR. Every UN state reviewed in 4-year cycles. Based on reports from the state, UN agencies, and civil society. Non-mandatory recommendations issued. Difference from treaty-based state reporting. UPR applies to all UN states, while treaty reporting applies only to ratifying states. UPR is general, while treaty reporting is more detailed. Special procedures. Over 50 mandates, including special rapporteurs, individuals, and working groups. Regional representatives. Thematic, for example, torture, extreme poverty, or country-specific. _ These notes provide a structured, detailed summary while focusing on key concepts, treaties, case law, and mechanisms related to human rights universality, extraterritorial obligations, and global human rights promotion. Let me know if you need any modifications. Next. Page 11.6.3 The UN Treaty-Based Human Rights System. Only states party to UN human rights treaties have obligations under these treaties. The ICPR and ICSCR cover general human rights, while specialized treaties focus on vulnerable groups or critical issues. Key treaties. CERD, 1965, Elimination of Racial Discrimination, influenced by post-colonial states and apartheid condemnation. CEDAW, 1979, Rights of Women. CRC, 1989, Rights of Children. CMW, 1990, Rights of Migrant Workers. CRPD, 2006, Rights of Persons with Disabilities. CAT, 1984, Against Torture. CED, 2006, Against Enforced Disappearances. The core treaties each establish a treaty monitoring body, committee, of independent experts, which oversee compliance. State obligations under these treaties. Implement treaty provisions in legislation, policies, and practices. Report periodically on implementation. Allow for complaints, individual, state-to-state, and inquiries. Follow recommendations from monitoring bodies. Underscore 11.6.3.1 State reporting. Purpose: monitors compliance through constructive dialogue. Process: states submit periodic reports. Treaty body reviews and questions state representatives. NGOs submit shadow reports to highlight discrepancies. Concluding observations issued with recommendations. Example: South Africa, ISCR. Recommendations included extending labor protections to domestic and farm workers, enforcing unannounced labor inspections, and improving complaint mechanisms. Underscore 11.6.3.2 Individual communications. Allows individuals to submit complaints against states, optional for states. Impact on sovereignty: more intrusive than reporting, as it can lead to a finding of treaty violations. Expansion of judicialization. Example: CRC originally lacked an individual complaints procedure, added in 2011, effective 2014. The optional protocol to ISCR, 2008, introduced a reasonableness test, influenced by South African constitutional jurisprudence. Case examples: South Africa, ICPR. Prince v. South Africa, no violation. McCallum v. South Africa, violation of Article 7 ICPR. Allegations of torture, incommunicado detention, and denial of medical treatment. Committee ruled South Africa violated Article 7, prohibition of torture. Underscore 11.6.3.3 Interstate communications. Allows one state to file a complaint against another. Rarely used due to fear of retaliation and geopolitical considerations. More recent treaties omit this procedure. Underscore 11.6.3.4 Inquiries. Most intrusive mechanism for state sovereignty. Optional protocol to CAT allows Subcommittee on Prevention of Torture to conduct periodic and ad hoc visits to detention facilities. CISCR can initiate inquiries into systematic violations of economic, social, and cultural rights. Underscore 11.6.3.5 General comments. Treaty bodies issue general comments. CEDAW uses general recommendations to clarify vaguely worded provisions. Though not legally binding, they have persuasive authority and influence interpretation and implementation. Underscore. This summary captures the core elements of the UN treaty-based human rights system, emphasizing key treaties, procedures, and their impact on states. Let me know if you need additional details. Next page. Here are your detailed study notes for regional systems for the promotion and protection of human rights. Regional HR systems. 11.7 Regional systems for the promotion and protection of human rights. Regional human rights systems have developed in Europe, the Americas, and Africa. Institutions in these regions monitor compliance with human rights norms. Emerging systems exist in the Arab and Islamic world and Southeast Asia. Underscore 11.7.1 The three main regional human rights systems. 11.7.1.1 Intergovernmental organizations. Each regional system operates within an intergovernmental organization. Europe, Council of Europe, Co., founded in 1949 to promote human rights and the rule of law. Distinct from the EU, which focuses on economic integration. Both organizations expanded post-Cold War to include Central and Eastern European states. EU Charter of Fundamental Rights reflects increasing EU involvement in human rights. The European Court of Justice, ECJ, Luxembourg, adjudicates economic disputes but has increasing human rights influence. Americas, Organization of American States, OAS, founded in 1948 to promote regional peace, security, and development. All 35 states in the Americas are members. Africa, Organization of African Unity, OAU, transformed into the African Union, AU, in 2002. 55 astronomical units members, including Morocco, which rejoined in 2017. Dispute over Western Sahara, SADR, remains unresolved despite UN efforts. Underscore 11.7.1.2 Normative frameworks. Each system is based on a primary treaty, supplemented by additional protocols and treaties. Europe. 1950 European Convention on Human Rights, ECHR, focuses on civil and political rights. Extended through protocols in the European Social Charter, 1961, revised in 1996. European Convention for the Prevention of Torture, 1987, also adopted. Americas. American Declaration on the Rights and Duties of Man, 1948. American Convention on Human Rights, 1969, entered into force in 1978, ratified by 25 states. Includes socioeconomic rights. Article 26. Protocol of San Salvador expanded socio-economic rights, but only two rights, unionization and education, are justiciable. USA and Canada are not parties to the convention. Africa. African Charter on Human and People's Rights, 1981, entered into force 1986, contains both civil and political rights and socio-economic rights, emphasizes duties of individuals and rights of peoples. Underscore. 11.7.1.3 Institutions. Europe. European Court of Human Rights, Strasbourg, is the sole adjudicative body since 1998. Protocol 11. Committee of Ministers of the Co-Oversees Compliance Pilot Judgment Procedure introduced to address systemic violations. Additional institutions. European Committee on Social Rights, monitors European Social Charter. European Committee for the Prevention of Torture, monitors Convention Against Torture. Americas. Two-tiered system. Inter-American Commission on Human Rights, 1959, Washington, D.C., quasi-judicial body. Inter-American Court of Human Rights, San Jose, Costa Rica, judicial body. Velázquez-Rodriguez v. Honduras, established state responsibility for enforced disappearances. States must accept court jurisdiction, and individuals cannot file cases directly. Africa. African Commission on Human and People's Rights, 1987, quasi-judicial body. African Court on Human and People's Rights, 2006, complements the Commission's protective mandate. Underscore. 11.7.1.4 Procedures. All three systems allow individual complaints. Inter-American System allows for precautionary measures to protect individuals at risk. European System. Protocol 14 allows dismissal of cases where applicants have not suffered a significant disadvantage. All systems incorporate various reporting mechanisms. Underscore. These notes provide a structured and comprehensive summary of regional human rights systems. Let me know if you need any refinements. I've compiled detailed study notes on regional human rights systems. Let me know if you need any refinements or additional focus on specific areas. Next page. Here are the study notes summarizing the regional human rights systems while maintaining key details on legislation, cases, and procedures. Let me know if you need any modifications. Regional HR systems. 11.7 Regional systems for the promotion and protection of human rights. Regional human rights systems exist in Europe, the Americas, and Africa. Institutions in these regions monitor compliance with human rights norms. Emerging systems in the Arab and Islamic world and Southeast Asia. 11.7.1 The three main regional human rights systems. 11.7.1.1 Intergovernmental organizations. Each system functions under an intergovernmental organization. Europe, Council of Europe, Co., established in 1949 to promote human rights and the rule of law. Distinct from the European Union, EU, which focuses on economic integration. EU evolved into a political union with an increased human rights focus. Co-membership, 47 states by 2018, broader than EU membership, 28 by 2013. European Court of Justice, Luxembourg, handles EU economic disputes but has influenced human rights law. Americas, Organization of American States, OAS, established in 1948, includes 35 states. Africa, Organization of African Unity, OAU, later transformed into the African Union, AU, in 2002. AU consists of all 55 African states. Morocco rejoined in 2017 after leaving in 1984 due to the Western Sahara dispute. 11.7.1.2 Normative frameworks. Each system is based on a principal human rights treaty. Europe, European Convention on Human Rights, ECHR, 1950. Initially covered only civil and political rights, expanded through protocols. European Social Charter, 1961, revised 1996, focuses on socio-economic rights, but weaker than ECHR. European Convention for the Prevention of Torture, 1987, independent monitoring mechanism. Americas, two key legal instruments. American Declaration of the Rights and Duties of Man, 1948. American Convention on Human Rights, 1969, effective 1978, ratified by 25 states, but not by the U.S. or Canada. Protocol of San Salvador, expands socio-economic rights, only unionization and education rights are justiciable. Africa, African Charter on Human and People's Rights, 1981, effective 1986. Covers civil, political, socio-economic rights, duties of individuals, and collective rights. Supplemented by additional treaties. 11.7.1.3 Institutions. Europe. European Court of Human Rights, ECTHR, Strasbourg, adjudicates individual complaints. ECTHR evolved from a commission and court system to a single court in 1998. Protocol 11. Complaints must exhaust domestic remedies first. Committee of Ministers oversees execution of judgments. Pilot judgment procedure addresses systemic violations. European Social Rights Committee and European Committee for Prevention of Torture monitor additional treaties. Americas. Inter-American Commission on Human Rights, 1959, Washington, D.C., investigates complaints, issues reports. Inter-American Court of Human Rights, San Jose, Costa Rica, established by the American Convention. Only hears cases referred by the Commission. Velázquez-Rodriguez v. Honduras, 1988, held Honduras responsible for enforced disappearances. Africa. African Commission on Human and People's Rights, 1987, quasi-judicial, handles complaints and promotional activities. African Court on Human and People's Rights, 2006, strengthens enforcement of human rights decisions. 11.7.1.4 Procedures. All three systems accept individual complaints. Inter-American System, notable for issuing precautionary measures to protect individuals under imminent threat. Each system incorporates reporting mechanisms to monitor human rights violations. The study notes have been created with all key details on regional human rights systems. Let me know if you need any refinements or additions. Next. Show in chat only. Page 11.7 Regional Systems for the Promotion and Protection of Human Rights. Regional human rights systems exist in Europe, the Americas, and Africa with functional institutions. Emerging systems in the Arab and Islamic world and Southeast Asia. 11.7.1 The three main regional human rights systems. Each system operates within intergovernmental organizations, has normative frameworks, institutions, and procedures. 11.7.1.1 Intergovernmental Organizations. Europe, Council of Europe, Co., 1949, aimed at human rights and rule of law. Distinct from the European Union, EU, which was founded for economic integration. European Court of Justice rules on EU economic integration but has increasingly overlapped with human rights. European Convention on Human Rights, ECHR, applies to all co-members, 47 by 2018, including Iceland, Ukraine, and Russia. Americas, Organization of American States, OAS, 1948, for regional peace, security, and development. Includes all 35 states in the Americas. Africa, African Union, AU, formerly Organization for African Unity, OAU, 2002. Includes all 55 African states, with Morocco rejoining in 2017. Dispute over Western Sahara remains unresolved. 11.7.1.2 Normative Frameworks. Europe. European Convention on Human Rights, 1950, focuses on civil and political rights. European Social Charter, 1961, revised 1996, covers socio-economic rights but allows states to choose provisions. European Convention for the Prevention of Torture, 1987. Americas. American Declaration on the Rights and Duties of Man, 1948. American Convention on Human Rights, 1969, in force 1978, ratified by 25 states, USA and Canada not parties. Protocol of San Salvador, expands socio-economic rights but only two, unionization, education, are justiciable. Africa. African Charter on Human and People's Rights, 1981, in force 1986, combines civil, political, and socio-economic rights. 11.7.1.3 Institutions. Europe. European Court of Human Rights, Strasbourg, France, adjudicates individual cases since Protocol 11, 1998. Committee of Ministers of Co oversees execution of judgments. Pilot judgment procedure addresses systemic violations. Additional bodies. European Committee on Social Rights, under Social Charter. European Committee for the Prevention of Torture. Americas. Inter-American Commission on Human Rights, 1959, Washington, D.C., receives complaints and refers cases. Inter-American Court of Human Rights, San Jose, Costa Rica, States must accept jurisdiction by a declaration. Velázquez Rodriguez v. Honduras, 1988, established state liability for disappearances. Africa. African Commission on Human and People's Rights, 1987, quasi-judicial body with a promotional and protective mandate. African Court on Human and People's Rights, 2006, complements the Commission's protective role. 11.7.1.4 Procedures. All three systems review individual complaints and communications. Inter-American system allows for precautionary measures to protect individuals at risk. Reporting and monitoring mechanisms differ across systems. Next page. 11.7.2 Other regional human rights systems. Additional regional systems exist in the Arab and Muslim worlds in Southeast Asia. These systems are less developed than the European, American, and African systems but are evolving. 11.7.2.1 Fledgling systems in the Arab and Muslim worlds. Human rights frameworks in the Arab and Muslim world are influenced by Islamic principles. Two major organizations. League of Arab States, 1945, focuses on unity among Arab states. Organization of Islamic Cooperation, OIC, 1969, promotes Islamic solidarity and cooperation. League of Arab States. Arab Charter on Human Rights, 1994. Failed due to lack of ratification. Revised Arab Charter on Human Rights, 2004, in force 2008. Invokes Sharia and other religious principles. Reaffirms principles of the Iqra and Iskr. Prohibits discrimination, including sex and religion. Allows derogation from rights under certain conditions but includes non-derogable rights. Protects fair trial rights but does not ban the death penalty, limited to serious crimes. Includes socio-economic rights such as right to work, education, property, cultural life, social security, and health. Weaknesses. Contains clawback clauses, for example, freedom of religion may be restricted by law. No individual complaints mechanism. Supervised by the Arab Human Rights Committee, reviews state reports every 3 years. Organization of Islamic Cooperation, OIC, 57 member states, 2018, including 27 African states. Cairo Declaration on Human Rights in Islam, 1990. Non-binding and Sharia-based. Article 24, all rights and freedoms are subject to Islamic law. Limits rights such as right to life, punishment regulations, and access to public office. Criticized for conflicting with universal human rights standards. Independent Permanent Human Rights Commission, IFRC, advisory body with limited powers. Covenant on the Rights of the Child in Islam, 2004. Requires 20 ratifications to enter into force, only 2 states ratified so far. Restrictive compared to UN treaties on child rights. Weak monitoring by the Islamic Committee on the Rights of the Child. Arab Court of Human Rights, proposed but premature due to existing weaknesses. 11.7.2.2 Developments in Southeast Asia. The Asia-Pacific region lacks a unified regional human rights system. Resistance to international human rights due to political disinterest and claims of Asian values. Association of Southeast Asian Nations, ASEAN, provides a basis for regional mechanisms. ASEAN Human Rights Mechanism. ASEAN Intergovernmental Commission on Human Rights, ICOR, 2009. Main regional human rights body. Mandate limited to consultation and promotion. No complaint mechanisms. Members serve as government representatives, with potential for recall. Some states appoint civil society representatives. ASEAN Human Rights Declaration, 2012. Provides a non-binding human rights framework. Lacks enforcement mechanisms. Key issues and challenges. Arab and Muslim regional systems prioritize Sharia, leading to conflicts with universal human rights. Weak enforcement and lack of individual complaint procedures. Southeast Asia's progress is slow due to political resistance and lack of strong institutions. Next page. Here's a detailed summary of the text while maintaining depth and structure. African HR System. 11.8 The African System for the Promotion and Protection of Human Rights. The Organization of African Unity, OAU, initially upheld non-interference in domestic affairs and did not obligate states to respect human rights. Human rights recognition in Africa gained traction in the 1990s, influenced by democratization and constitutional reforms. Key treaties include 1990 African Charter on the Rights and Welfare of the Child, 1998 Protocol to the African Charter on the Establishment of the African Court on Human and People's Rights. The OAU transformed into the African Union, AU, with a stronger human rights focus under the AU Constitutive Act. Article 4H of the AU Constitutive Act allows intervention in cases of genocide, crimes against humanity, or war crimes, embodying the responsibility to protect principle. 11.8.1 The political organs of the OAU/AU1. AU Assembly of Heads of State and Government. Supreme organ of the AU, meets twice annually. Determines AU policies, including human rights treaties, for example, Women's Rights Protocol. Oversees and funds human rights treaty bodies. Elects members of human rights institutions. Initially, members of the African Commission lacked independence, but later reforms addressed this concern. 2. Executive Council. Composed of ministers of foreign affairs of AU states, reviews human rights reports and is more engaged in human rights issues than the Assembly. Directed the revocation of observer status for the NGO Coalition of African Lesbians, CAL, undermining the African Commission's independence. 3. Peace and Security Council, PSC, a standing decision-making body for conflict prevention and resolution. Highlights the link between peace, security, and human rights. Supports post-conflict reconstruction and the protection of vulnerable groups. Cooperates with the African Commission, but synergy remains underdeveloped. 4. Pan-African Parliament, PAP, functions mainly as a deliberative and oversight body. Advocates democracy, good governance, and human rights. Conducts fact-finding missions, for example, Darfur, Côte d'Ivoire, DRC, Mauritania. Limited impact beyond discussions. 11.8.2 Norms. Encompasses key human rights instruments: OAU Refugee Convention, African Charter, African Children's Charter, Women's Protocol, Kampala Convention. Some regional norms are lex specialis, specific adaptations of general international principles. 11.8.2.1 OAU Refugee Convention, 1969, expands the 1951 UN Refugee Convention definition of refugee, recognizes individuals fleeing due to events seriously disturbing public order, takes into account broader socio-political and natural disaster factors beyond persecution, aligns with global standards while addressing Africa-specific challenges. 11.8.2.2 African Charter on Human and People's Rights. Balances progressive human rights protection and state sovereignty. Features an ambiguous complaints mechanism and clawback clauses that may limit rights. Operated by 11 part-time commissioners meeting twice a year. 11.8.2.2.1 Rights of Peoples. Recognizes both individual and collective rights. People's rights include self-determination, control over natural resources, development, and environmental well-being. Interpretations of peoples. 1. Encompasses all inhabitants of a state. 2. Includes distinct minority groups based on shared characteristics. 3. Applies to populations under colonial or alien rule. Case law. DRC v Burundi, Rwanda, and Uganda, people refers to all affected Congolese. Southern Cameroonians case, common history and political outlook suffice to classify as peoples. Katani's secession case, the right to self-determination exists but must align with constitutional options. Southern Cameroon case, the African Commission opposed secession. 11.8.2.2.2 Indigenous peoples' rights. The Charter does not explicitly mention indigenous peoples, but the African Commission recognizes them. Criteria for indigenous status in Africa. 1. Long-standing presence in a territory. 2. Distinct lifestyle closely tied to land and natural resources. 3. Political and economic marginalization. 4. Self-identification and recognition by surrounding communities. Legal developments. Widespread African support for the UN Declaration on the Rights of Indigenous Peoples, 2007. Ndoroy's case, 276-2003, recognized the Ndoroys as indigenous and ruled their forced eviction violated multiple rights. Ogik case, African Commission v Kenya. The African court ruled that the eviction of the Ogik from the Mau Mau forest violated their right to development and consultation under Article 22 of the African Charter. Here's the summary and detailed bullet points while preserving the depth of the original text. Let me know if you need any refinements. Next. Never show in Canvas. Page 11.8 The African System for the Promotion and Protection of Human Rights. OAU, Organization of African Unity, founded in 1963 with a strong focus on non-interference in domestic affairs, did not impose obligations on member states to respect human rights. No initial treaties or institutions dedicated to human rights. Human rights developments in Africa. Close correlation between domestic and regional human rights observance. The 1990s saw human rights progress with democratization and constitutional reforms. The African Commission became more assertive in its mandate. Key human rights treaties adopted. 1990 African Charter on the Rights and Welfare of the Child. 1998 Protocol on the African Court on Human and People's Rights. Transition from OAU to AU, African Union, OAU transformed into AU, 2002, due to changing realities and pressure from Libyan leader Gaddafi. AU Constitutive Act made human rights central. Article 4H allows the AU to intervene, military force included, in cases of genocide, war crimes, or crimes against humanity. Incorporates the responsibility to protect principle. _ 11.8.1 Political organs of the OAU/AU, AU Assembly of Heads of State and Government. Highest AU organ, meeting twice annually. Determines AU's common policies, including adoption of human rights treaties, for example, Women's Rights Protocol. Funds and oversees African human rights treaty bodies. Adopts and enforces findings of the African Commission, Article 59 of the African Charter. Elects members of human rights bodies, ensuring their independence. Executive Council, former OAU Council of Ministers, consists of Ministers of Foreign Affairs or designated ministers. Reviews AU Assembly decisions, often more influential in human rights matters. Since 2003, mandated to consider African Commission's reports, leading to more scrutiny. Example, 2015 African Commission granted observer status to NGO Coalition of African Lesbians, CAL. Executive Council rejected it, citing African values. In 2018, the Commission revoked its decision under political pressure, raising concerns about its independence. Peace and Security Council, PSC, permanent decision-making body for conflict prevention, management, and resolution. PSC protocol emphasizes human rights, linking peace, security, and human rights. Assists with social/economic reconstruction, demobilization and reintegration, for example, child soldiers, refugee resettlement. Should cooperate with the African Commission, but collaboration remains limited. Pan-African Parliament, PAP, primarily deliberative, but expected to evolve into a legislative organ. Oversees AU Executive, promotes human rights, democracy, and good governance. Has passed human rights resolutions, for example. 2005, called for the release of detained Ugandan opposition leader Dr. Kizza Besigye. 2004, sent a fact-finding mission to Darfur, leading to similar missions in Côte d'Ivoire, DRC, and Mauritania. Still mainly a discussion forum rather than a policy-making body. _ 11.8.2 Norms, Key Human Rights Instruments in Africa. African Human Rights Instruments serve as lex specialis, addressing Africa's unique challenges. Major treaties. 1969 OAU Refugee Convention. 1981 African Charter on Human and People's Rights. 1990 African Charter on the Rights and Welfare of the Child. 2003 Women's Rights Protocol. 2009 Kampala Convention on Internally Displaced Persons. _ 11.8.2.1 OAU Refugee Convention. Expands UN Refugee Convention, 1951, definition of refugee. UN Convention, refugee must show a well-founded fear of persecution. OAU Convention broadens it, includes those fleeing due to events seriously disturbing public order. Includes factors like famine and natural disasters as grounds for refugee status. No conflict with UN standards, rather, it provides a regional complement. _ 11.8.2.2 African Charter on Human and People's Rights, 1981, a compromise between progressive human rights advocates and state sovereignty defenders. Flaws. Weak enforcement mechanisms. Ambiguous complaints system. Clawback clauses that allow states to limit rights. 11.8.2.2.1 Rights of Peoples. Recognizes collective rights of peoples, besides individual rights. Includes right to existence, right to self-determination, right to natural resources, development, peace, and a satisfactory environment. Interpretations of peoples. 1. All inhabitants of a state, for example, all Congolese and DRC v Burundi, Rwanda and Uganda case. 2. Ethnic, linguistic, or religious minorities, for example, Southern Cameroonians recognized as peoples based on history and political outlook. 3. Oppressed colonial populations, but may be obsolete post-independence. Self-determination and secession. Katanese secession case, Katanese People's Congress v. Zaire. The African Commission rejected Katanga's claim to independence, stressed that self-determination should be pursued within state boundaries unless systematic oppression exists. Southern Cameroon case. The Commission firmly rejected secession as a solution. _ 11.8.2.2.2 Indigenous Peoples' Rights. Not explicitly mentioned in the Charter, but recognized under Peoples' African Commission's Working Group Report identifies characteristics of indigenous groups. 1. Long-standing presence in a territory. 2. Distinct lifestyle reliant on natural resources. 3. Political/economic marginalization, often threatening existence. 4. Self-identification as indigenous, acknowledged by others. Unlike the international definition, Africa does not define indigenous status based on colonial conquest. Landmark indigenous rights cases. 1. Endorois case, Communication 276/2003, Kenya forcibly evicted Endorois people from their ancestral lands. Violations included religious rights, removal from sacred sites, right to property, no compensation. African Commission recognized them as indigenous people. 2. Ogik case, African Commission v. Kenya, Ogik were evicted from Mau Mau Forest. African court ruled this violated their right to development, Article 22. _ Key takeaways. The African human rights system evolved slowly, hindered by sovereignty concerns. The AU Constitutive Act introduced human rights intervention mechanisms. African treaties often provide regional enhancements to global human rights norms. Political bodies like the AU Assembly and Executive Council shape human rights enforcement. The African Charter remains controversial due to weak enforcement and clawback clauses. Indigenous rights and people's rights are gaining recognition through case law. Next page. African Human Rights System, Socioeconomic Rights and Other Protections. 11.8.2.2.3 Inclusion of Justiciable Socioeconomic Rights. The African Charter is the first international human rights instrument to include both civil, political and socio-economic rights as equally justiciable. Socio-economic rights in the Charter are minimally provided, mainly the right to health and education. Drafters intentionally excluded rights such as food, shelter, and water to avoid overburdening fledgling states. Key cases on justiciability of socio-economic rights. 1. Social and Economic Rights Action Center, SARAC, and Another v. Nigeria, Ogoniland case, 2001, Nigerian government was held responsible for oil pollution and human rights violations in the Niger Delta. The commission expanded socio-economic rights, housing and food, based on the implied rights theory, highlighted the negative effects of government-corporate collusion on human rights. 2. Sudan Human Rights Organization and Center on Housing Rights and Evictions, COHR, v. Sudan, Darfur case, 2009, the Commission avoided reliance on implied rights theory. Instead, it expanded the right to health to include access to water. Other developments. African Women's Protocol, 2003, formalized the expanded socio-economic rights from the Ogoniland case. Adoption of soft law instruments further developed socio-economic rights protections. Purohit and Another v. the Gambia, first case on state obligations to fulfill socio-economic rights, applied the concrete and targeted steps approach, assessing measures based on available resources and reasonableness. _ 11.8.2.2.4 Right to Development. African Charter, Article 22. First international treaty to recognize the right to development as a binding right, includes both individual and collective state obligations. Individual states must address internal developmental disparities. NPAD, New Partnership for Africa's Development, is an example of collective African efforts towards economic development. Key case, Endorois case. Eviction of Endorois people from ancestral land for a game reserve without consultation equals violation of Article 22. Violation was both procedural and substantive, lack of participation and adverse effects on well-being. _ 11.8.2.2.5 Individual duties. African Charter uniquely emphasizes individual duties to other individuals, family, community, the state, the African and international community. No case law or communications on individual duties yet. Inspired by Senghore's 1979 speech, which argued that in African societies, rights are intertwined with duties, contrasting with the Western individualistic approach. African Commission's guidelines require states to report on legislation, regulations, and court decisions enforcing individual duties. States must instill individual duties in their citizens. _ 11.8.2.3 African Children's Charter. Adopted in 1990, shortly after the UN Convention on the Rights of the Child, CRC, 1989, provides stronger protection than the CRC in key areas. 1. Child soldiers. CRC allows child recruitment in hostilities, while the African Children's Charter completely outlaws child soldiers. 2. Child marriage. CRC allows exceptions where a child reaches majority before 18. African Children's Charter explicitly prohibits child marriage and requires 18 years as the minimum age. 3. Protection of internally displaced children. Extends protections to internally displaced children, unlike the CRC. Additional protections. Allows individual complaints against states, a feature absent in the CRC. _ 11.8.2.4 Women's Protocol, Maputo Protocol, adopted in 2003, expands upon CEDAW, adapting it to African realities. Provides broader and clearer protections than CEDAW. Key expansions and protections. Medical abortion, first treaty to provide for a right to safe abortion under circumstances. HIV/AIDS protections, right for women to know their partner's HIV status. Marriage laws. Encourages monogamy. Requires states to criminalize marital rape. Sets minimum marriage age at 18. All marriages must be recorded in writing. Violence against women. Requires domestic violence laws and recognition of forced sex in private spaces. Women in armed conflict. Expanded protection for women refugees. Prohibits recruitment of girls in armed conflicts. _ 11.8.2.5 Internally displaced persons, IDPs. Africa has over 9 million IDPs, making up 1/3 of the world's displaced population. Causes. Internal armed conflicts. Intercommunal violence, for example, resource control, political power struggles. Kampala Convention, 2009, first binding treaty on IDP protection in the world. Converts UN norms into legally binding state obligations. Key provisions. Definition, Article 1K. IDPs are people forced to flee but remain within their country's borders. The distinction between IDPs and refugees is that IDPs have not crossed an international border. State obligations. Article 3. States must protect IDPs and prevent displacement. Criminal liability for individuals and corporations responsible for displacement. Multinational and private military companies can be held accountable. Humanitarian protections. Geneva Conventions, Article 59, and Additional Protocol I, Article 70, require protection of civilians in armed conflict. Unhindered humanitarian aid delivery. ICRC 2005 study recognizes these as customary international law. Kampala Convention, Article 57, integrates these protections into state duties. _ Conclusion. The African human rights system has expanded human rights protections through 1. Justiciable socio-economic rights and progressive adjudication by the African Commission. 2. Inclusion of development rights with a focus on collective obligations. 3. Recognition of individual duties alongside rights. 4. Enhanced protection for vulnerable groups, women, children, and IDPs, through region-specific treaties. Next page. 11.8.3 Institutions and processes under the African Regional Human Rights System. The African Regional Human Rights System includes institutions and processes that facilitate human rights realization. Key institutions. African Commission on Human and People's Rights. African Court on Human and People's Rights. African Committee of Experts on the Rights and Welfare of the Child. African Peer Review Mechanism, APRM, UNDRPAD. _ 11.8.3.1 African Commission on Human and People's Rights. Mandate under Article 45 of the African Charter. 1. Promotion of human and people's rights. Collects documents, conducts research, and organizes conferences on human rights, disseminates information and supports national and local human rights institutions, formulates legal principles for African governments, cooperates with African and international institutions on human rights. 2. Protection of human and people's rights. Ensures rights protection under the African Charter. 3. Interpretation of the African Charter. Provides interpretations upon request from a state party, an OAU institution, or a recognized African organization. 4. Additional responsibilities. Undertakes tasks assigned by the Assembly of Heads of State and Government. Promotional mandate. Conducts visits to educate governments and the public on human rights and the Charter. Establishes special rapporteurs and working groups on thematic human rights issues. Requires state reporting on domestic implementation of the Charter. Issues concluding observations on state reports. Challenges. States non-compliance. Many submit reports irregularly, late, or not at all. Special mechanisms limited effectiveness. States must agree to visits. Protective mandate. Handles communications, complaints. Individual communications, handled 442 cases in 25 years, 361 finalized. Interstate complaints, only one case decided. Burundi, Rwanda, and Uganda found in violation of the Charter over actions in the DRC. Conducts on-site investigations for serious human rights violations. Fact-finding missions to Darfur, 2004, and Burundi, 2015. Strengthening of mandate. Allowed individual complaints mechanism. Increased extraordinary sessions and session durations. Adopted a progressive interpretation of the Charter, including a proportionality test for rights limitations under Article 27(2). Key contributors to progress. 1. Civil society, NGOs. NGOs play a major role in lobbying and advocacy. 518 NGOs held observer status by 2018, submit shadow reports, resolutions, and advocate for reforms. 2. Independent and progressive commissioners. Academics, legal practitioners, and human rights activists have strengthened jurisprudence, led to adoption of progressive standards, for example, rights of women, internally displaced persons. Challenges and limitations. 1. Confidentiality of protective activities. Article 59 of the Charter. Protective measures remain confidential until the Assembly of Heads of State and Government decides otherwise. Reports have been delayed to allow state responses. Political interference. Executive Council retracted observer status of NGO CAL over claims of not upholding African values. 2. Lack of binding decisions. Commission's decisions are only recommendations, not legally binding. Good v. Botswana, good case. Botswana refused to implement the Commission's ruling. Commission reported non-compliance to the Executive Council, but no action was taken. 3. Dependence on political will. The effectiveness of the Commission depends on political organs such as the Executive Council and Assembly of Heads of State and Government. Lack of enforcement mechanisms weakens the system's impact. Next. Page 11.8.3.2 African Human Rights Court. Purpose and jurisdiction. Established to complement the African Commission's protective mandate, has both contentious and advisory jurisdiction. Contentious jurisdiction resolves disputes between parties, decisions are binding. Advisory jurisdiction provides legal opinions on treaty interpretations, not binding but persuasive. Contentious jurisdiction applies only to states that have ratified the African Human Rights Court Protocol. 30 astronomical unit states as of 2018. Individual and NGO complaints are first submitted to the African Commission. If a state fails to comply with a Commission decision within 6 months, the case may be referred to the court. As of 2018, the African Commission had not referred any decided cases to the court. Ndoroy's case, 2009, a key case for referral, but non-compliance is difficult to establish due to political complexities. Direct individual complaints. Possible if a state has made an optional declaration under Article 34(6) of the Protocol. Bypasses the African Commission, reducing delays. Only 8 states had made this declaration as of 2018, Rwanda withdrew in 2017. Advisory jurisdiction. Article 4 of the Court Protocol grants standing to the AU and its organs. AU member states. African organizations recognized by the AU. As of 2018, the Court issued only one advisory opinion, confirmed that the African Children's Rights Committee lacked competence to refer cases. NGO requests for advisory opinions. Rejected requests from NGOs with observer status at the African Commission. Ruled that observer status with an AU body does not equate to AU recognition. Scope of jurisdiction extends to the African Charter, the Protocol, and any other relevant human rights instrument ratified by the state concerned, for contentious cases. Any relevant human rights instrument, for advisory opinions. Potential overlaps may conflict with UN human rights bodies like the Human Rights Committee. Improvements over the Commission. Provides binding judgments. Has power to order a wide range of remedies. Public hearings enhance transparency. AU oversight ensures enforcement, though compliance relies on political will, civil society participation, and follow-up actions. Planned institutional changes. Proposed merger with AU Court of Justice. 2008, AU adopted Merged Court Protocol, creating a two-chamber court, Human Rights and General Affairs. Intended to reduce duplication and costs. Expanded jurisdiction, Malabo Protocol, 2014, proposed third chamber for international and transnational crimes. Crimes covered, genocide, crimes against humanity, corruption, human trafficking, and illegal resource exploitation. Requires 15 ratifications to take effect, none as of 2018. Controversy, Article 46 bis. Grants immunity from prosecution to sitting heads of state and senior officials. Raises concerns about lack of accountability. Court decisions, 2018 summary, 23 violations found, mostly against Tanzania. Fair trial issues. Key cases. Mtakila v Tanzania, found that requiring political party membership for elections violated Article 13, African Charter. APDH v Côte d'Ivoire, Electoral Commission composition violated multiple African legal instruments. Kanate v Burkina Faso, prison sentence for defamation violated African Charter, Article 9, and ICPR, Article 19. In Gabariyumuhoza v Rwanda, opposition leader's sentence for minimization of genocide was disproportionate. Provisional measures. Libya, 2011, 2013, ordered Libya to stop human rights violations during armed conflict. Ordered protection for Saif al-Islam Gaddafi, access to lawyer, visits, personal safety. Libya did not comply. AU's Executive Council acknowledged non-compliance but took no action. Figure 11.1, potential future evolution of the African Court. Next page. African Human Rights Court. Established to address weaknesses in the African Commission's protective mandate. Jurisdiction. Contentious, handles disputes between parties, decisions are binding. Advisory, provides non-binding opinions on treaty interpretation. Contentious jurisdiction applies only to states that ratified the African Human Rights Court Protocol. 30 astronomical units states by 2018. Individual complaints must go to the African Commission first, which may refer cases to the court if a state fails to comply with non-binding findings. Direct access to the court is available only if a state has made an optional declaration under Article 34.6. 8 states by 2018. Rwanda withdrew in 2017. Advisory opinions can be sought by the AU organs, member states, and AU-recognized organizations. Scope of jurisdiction extends to the African Charter, Protocol, and any other relevant human rights instrument ratified by the state. Advantages over the African Commission. Gives binding judgments. Can order varied remedies. Conducts hearings in open court. AU's political organs supervise implementation. Challenges. Compliance depends on state political commitment, civil society engagement, and enforcement by AU organs. Institutional evolution. 2008, AU adopted the Merged Court Protocol to combine the African Human Rights Court and the AU Court of Justice into the African Court of Justice and Human Rights, 2 chambers, Human Rights and General Affairs. 2014, AU adopted the Malabo Protocol, adding a third chamber for international crimes, for example, genocide, corruption, trafficking. Criticism of the Malabo Protocol. Grants immunity to sitting heads of state and senior officials, Article 46a bis. By 2018, no ratifications of the Malabo Protocol, making its implementation uncertain. Key cases. Fair trial rights, majority of violations found, 23 cases by 2018, mostly against Tanzania. Voting rights. Mtakila v Tanzania, restricting independent candidacy violated Article 13 of the African Charter. APDH v Côte d'Ivoire, Electoral Commission structure violated regional democracy treaties. Freedom of expression. Kanate v Burkina Faso, defamation imprisonment violated Article 9, African Charter, Article 19, ICPR, and ECOWAS Treaty. In Gabriel v. Rwanda, genocide denial laws violated Articles 9, African Charter, and 19, ICPR. Provisional measures. Libya, 2011 and 2013, court orders to prevent rights violations and ensure detainee protections were ignored. African Children's Rights Committee. Created in 1990 to monitor the African Children's Charter, functions similar to the African Commission. Receives communications, individual and interstate. Examines state reports. Conducts fact-finding missions. Engages in promotional activities. Challenges. Resource constraints limit effectiveness. Slow adoption of rules of procedure delayed operations. Recent developments. Since 2008, examines state reports and holds CSO forums before sessions. Notable cases. Uganda, 2001 to 2005, found guilty of recruiting and using child soldiers. Senegal, failed to enforce laws against child begging and exploitation. NPAD's African Peer Review Mechanism, APRM, voluntary process under NPAD for reviewing political, economic, and corporate governance. Basis, the Declaration on Democracy, Political, Economic, and Corporate Governance. Philosophy, Good Governance and Democracy. Poverty Reduction. Process. States voluntarily sign a Memorandum of Understanding, MOU. Heads of State, APRM Forum, Conduct Reviews. Technical Assessments by Panel of Eminent Persons, APRM Secretariat, and Experts. Comparison with Universal Periodic Review, UPR. Scope, UPR focuses only on human rights, APRM includes broader governance issues. Reviewer, UPR is conducted by HRC government delegates, APRM by AU heads of state. States covered, UPR reviews all UN members, APRM covers only selected AU states. Let me know if you need any modifications or additional details. Next. Correct note will be posted. Page. Got it. Go ahead and post the corrected note. Next. Page. Your table looks good. Let me know if you need any formatting adjustments or additional edits. Next. Create the table. Page. Here's your table in a clear and structured format. Item of comparison: Universal Periodic Review, UPR, African Peer Review Mechanism, APRM. States reviewed all UN members, selected AU member states. Reviewing entity government delegates to HRC, selected AU heads of state. Scope of review: only human rights, economic, political, and corporate governance, including human rights. Let me know if you need any modifications. Next. Page. Here's a structured table summarizing the key sub-regional economic communities in Africa and their roles in human rights protection. Regional Economic Community, REC, Judicial Organ, Human Rights Jurisdiction. Key cases. ECOWAS, Economic Community of West African States, ECOWAS Court of Justice, explicit jurisdiction to hear human rights cases based on the African Charter. Chief Ibrahim v. the Republic of Gambia, arrest without a warrant violated Articles 6 and 7 of the African Charter. Hadija Toumani Karaou v. Niger, Niger failed to curb contemporary forms of slavery. EAC, East African Community, EAC Court of Justice, no explicit human rights jurisdiction, but can interpret the EAC Treaty, which includes principles of human rights and rule of law. Uganda case, rearrest of accused persons after being granted bail violated the rule of law. SADC, Southern African Development Community, SADC Tribunal, now suspended, had jurisdiction under the SADC Treaty to decide human rights cases until suspension in 2014. Mike Campbell, Private, Limited v. Republic of Zimbabwe, Zimbabwe's land reform violated SADC Treaty's non-discrimination clause. Let me know if you need any refinements. Next. Page. 11.10.3 Interpretive Guidance. Section 39(1) of the Constitution, Interpretation of the Bill of Rights. Courts, tribunals, and forums must a. Promote values underlying an open, democratic society based on human dignity, equality, and freedom. B. Consider international law. C. May consider foreign law. Section 233. Courts must prefer reasonable interpretations consistent with international law over those that are inconsistent. Role of international law in interpretation. Historical significance. International law played a crucial role in exposing apartheid's injustices. Minimalist obligation. Courts are required only to consider, not enforce, international law. Limited engagement. South African courts rarely rely on international law due to overlap with the Bill of Rights. Many international norms already incorporated. Judicial reluctance to engage in comparative analysis. Director of Public Prosecutions, Transvaal. The Constitutional Court acknowledged that Section 28(2), Best Interests of the Child, was inspired by the UN Convention on the Rights of the Child and the African Children's Charter. Judicial Approach to International Law. S.V. Mqwanyan. Chaskalson P. International Agreements and Customary International Law, both binding and non-binding, form a framework for Bill of Rights interpretation. Courts often enumerate treaty provisions but fail to analyze international jurisprudence. Section 39(1)(b) Obligation. Courts should not only refer to treaties but also engage with international case law and judicial reasoning. Glenister v. President of the Republic of South Africa. Court emphasized Section 39(1)(b)'s mandatory nature. International law was used to conclude that an anti-corruption unit was constitutionally required. National Commissioner of Police v. Southern Africa Human Rights Litigation Center. The SAPS was compelled to investigate crimes against humanity in Zimbabwe using international human rights law. SADC Tribunal Case. President violated the Constitution by colluding with SADC leaders to suspend the SADC Tribunal, limiting access to justice. Proposed methodological approach. 2 categories of international law. 1. Binding obligations. Treaties ratified and enacted into domestic law. Ratified but non-domesticated treaties. Customary international law. 2. Non-binding but persuasive. Unratified treaties and soft law standards. International case law, for example, European Court of Human Rights jurisprudence. _ 11.10.4 Domestic enforcement of international decisions. Lack of domestic enforcement framework. No constitutional/statutory provision for enforcing international court decisions, for example, SADC Tribunal, African Human Rights Court. Campbell Case, SADC Tribunal. SADC Tribunal ordered Zimbabwe to pay compensation. Zimbabwe refused. Enforcement sought in South Africa. Cape High Court upheld enforcement by attaching Zimbabwean assets in Cape Town. Supreme Court and Constitutional Court affirmed this decision. SADC Protocol on Tribunal Enforcement, Article 32, 1. Domestic enforcement follows the rules for foreign judgments. 2. SADC states must execute tribunal decisions. 3. Tribunal decisions are binding and enforceable in member states. FIT Case, expanding enforcement under common law. Issue: South African civil procedure rules for foreign judgments did not cover international court rulings. Common law adaptation. Foreign judgments must meet jurisdiction, finality, and public policy criteria. FIT judgment conformed to these criteria. Court expanded common law to include international court decisions, ensuring effective enforcement. Key case law. S.V. Mqwanyan, 1995. International law provides interpretative guidance for the Bill of Rights. Director of Public Prosecutions, Transvaal, 2009. Best Interests of the Child Principle rooted in international law. Glenister v. President of South Africa, 2011. International law required an anti-corruption unit. National Commissioner of Police v. SA Human Rights Litigation Center, 2014. SA must investigate crimes against humanity in Zimbabwe. SADC Tribunal Case, 2018. Presidential actions violating international law deemed unconstitutional. FIT Case, 2013. South African common law expanded to enforce international court judgments. Next. Back to creating of study notes. Page. Got it. Here are your study notes for 11.10.3 Interpretive Guidance and 11.10.4 Domestic Enforcement of International Decisions. Interpretive Guidance. 11.10.3 Interpretive Guidance. Section 39(1) of the Constitution, Interpretation of the Bill of Rights. Courts, tribunals, and forums must a. Promote human dignity, equality, and freedom. B. Consider international law. C. May consider foreign law. Section 233. Courts must favor interpretations consistent with international law. Role of international law in interpretation. Historical significance, used to expose apartheid's injustices. Minimalist obligation, courts must only consider, not enforce, international law. Limited engagement, courts rarely cite international law due to overlap with the Bill of Rights and judicial reluctance. Key case, Director of Public Prosecutions, Transvaal. Section 28(2), Best Interests of the Child, Influenced by international treaties, for example, UN Convention on the Rights of the Child. Judicial approach to international law. S. V. McQuanian, International Agreements and Customary Law form an interpretive framework. Section 39(1)B Obligation. Courts should analyze international case law, not just treaties. Glenister v. President of South Africa. International law required the creation of an anti-corruption unit. National Commissioner of Police v. SA Human Rights Litigation Center. SAPS compelled to investigate crimes against humanity in Zimbabwe. SADC Tribunal case. President violated the Constitution by suspending the SADC Tribunal. Proposed methodological approach. Binding obligations. 1. Ratified and domesticated treaties. 2. Ratified but non-domesticated treaties. 3. Customary international law, non-binding but persuasive. Unratified treaties, soft law, and international case law, for example, European Court of Human Rights. _ 11.10.4 Domestic enforcement of international decisions. Lack of domestic enforcement framework. No constitutional/statutory provision for enforcing international court decisions, for example, SADC Tribunal, African Human Rights Court. Campbell case, SADC Tribunal. SADC Tribunal ordered Zimbabwe to pay compensation. Zimbabwe refused. Enforcement sought in South Africa. Cape High Court upheld enforcement by attaching Zimbabwean assets. Supreme Court and Constitutional Court affirmed enforcement. SADC Protocol on Tribunal Enforcement, Article 32, 1. Domestic enforcement follows foreign judgment rules. 2. SADC states must execute tribunal decisions. 3. Tribunal decisions are binding and enforceable. FIT case, expanding enforcement under common law. Issue, South African civil procedure rules did not cover international court rulings. Common law adaptation. Foreign judgments must meet jurisdiction, finality, and public policy requirements. Court expanded common law to enforce international judgments. Key case law. S. V. McQuanian, 1995. International law provides interpretative guidance. Director of Public Prosecutions, Transvaal, 2009. Best interests of the child principle rooted in international law. Glenister v. President of South Africa, 2011. International law required an anti-corruption unit. National Commissioner of Police v. SA Human Rights Litigation Center, 2014. SA must investigate crimes against humanity in Zimbabwe. SADC Tribunal case, 2018. Presidential actions violating international law deemed unconstitutional. FIT case, 2013. Common law expanded to enforce international judgments. Your study notes are ready. Let me know if you need any modifications or additional sections. Next. Page 11.9 Sub-regional economic communities in Africa and human rights promotion and protection. Regional economic communities, RECs. Established primarily for economic integration, trade, and growth. Major RECs. ECOWAS, Economic Community of West African States, EAC, East African Community, SADC, Southern African Development Community. Each has a judicial organ allowing individual access at some stage. Potential to develop sub-regional human rights systems, especially where REC courts have jurisdiction over human rights. Driven by weaknesses in the African regional system, for example, non-binding African Commission findings and key violators, for example, Zimbabwe, refusing African court jurisdiction. ECOWAS Court of Justice. Explicit jurisdiction over human rights cases under the African Charter. Individuals in member states can directly institute cases. Key cases. Chief Ebrahim Navy, the Republic of Gambia. Arrest without a warrant and illegal detention of a journalist violated Articles 6 and 7 of the African Charter. Case against Niger. Failure to curb contemporary forms of slavery violated the African Charter. EAC Court of Justice. Jurisdiction to interpret and apply the EAC Treaty. No direct human rights jurisdiction yet. EAC Council may extend in the future. Key case. Case against Uganda. Uganda rearrested 14 accused persons after bail was granted. Court ruled it lacked jurisdiction to rule directly on human rights violations. However, found that Uganda violated the rule of law, a fundamental principle of the EAC. SADC Tribunal. Jurisdiction under SADC Treaty to rule on cases involving human rights, democracy, and the rule of law. Key case. Mike Campbell, Private, Limited and others v. Zimbabwe. Challenged Zimbabwe's land reform program, Constitutional Amendment 17. Tribunal ruled. Amendment 17 violated Article 4C of the SADC Treaty, right to access justice. Discriminatory targeting of white farmers violated Article 6.2, prohibiting racial discrimination. Ordered Zimbabwe to restore land ownership and pay compensation. Zimbabwe refused to comply and rejected the tribunal's legitimacy. SADC Summit, 2010, blocked new appointments to the tribunal. 2014, SADC amended its treaty to abolish individual access to the tribunal. By 2018, the tribunal was still not restored or functional. 11.10 Domestic enforcement of international human rights. Focus on South Africa. Primary responsibility: states must protect rights domestically. International law is complementary. South African approach examines domestication, self-execution, interpretive guidance, and enforcement. 11.10.1 Domestication. Section 231(4) of the South African Constitution. Treaties become law only when enacted into national legislation. Self-executing treaty provisions, approved by Parliament, become law unless inconsistent with the Constitution or another act. Examples of domesticated treaties. Children's Act 38 of 2005 implements Hague Convention on Inter-Country Adoption. Section 256, if national law conflicts with the Convention, the Convention prevails. Implementation of the Rome Statute of the ICC Act 27 of 2002. Incorporates ICC crimes, for example, crimes against humanity, into South African law. Prevention and Combating of Torture of Persons Act 13 of 2013. Domesticates UN Convention Against Torture, CAT. Partial domestication. Child Justice Act 75 of 2008 references CRC and African Charter but only as an interpretive guide. 11.10.2 Direct application, self-execution. Self-executing treaties can be directly enforced without prior incorporation into domestic law. Determining self-execution. Treaty provision must be clear and capable of direct enforcement. Must align with domestic legal principles for internal effect. Judicial reluctance to use self-executing provisions. Rootboom case. Justice Yacob noted international law may be directly applicable, but context unclear. Scholarly views. Van der Vyver, all treaties are non-self-executing, calling the concept nonsensical. De Wet, treaties should be treated as non-self-executing because they do not create direct litigation rights for private parties. Key case, Claassen v. Minister of Justice and Constitutional Development. Question: could Article 9(5) of the ECPR, right to compensation for unlawful detention, be self-executing? Court ruled against self-execution, failing to provide clarity on its application. Criticism: Kielander argued Article 9(5) should have been declared self-executing. Summary of key points. Subregional Economic Communities, RECs, ECOWAS, Direct Human Rights Jurisdiction, EAC, no formal jurisdiction, but rules on rule of law violations. SADC, Tribunal suspended, individual access abolished. South Africa and international human rights law. Domestication, required for non-self-executing treaties. Self-executing treaties, courts hesitant to enforce directly. Judicial cases, generally avoid ruling on self-execution. These notes summarize the core aspects of subregional human rights mechanisms in Africa and South Africa's approach to international human rights law enforcement. Let me know if you need adjustments. Next. Page 11.10.3 Interpretive Guidance. Section 39(1) of the Constitution, guides interpretation of the Bill of Rights. A. Must promote values of an open, democratic society based on dignity, equality, and freedom. B. Must consider international law. C. May consider foreign law. Section 233. Courts must prefer interpretations of legislation consistent with international law over those that are inconsistent. Historical context. South Africa's reliance on international law during anti-apartheid activism contributed to its central role in the constitutional framework. Judicial application of international law. Courts only need to consider, not necessarily apply or enforce, international law. Minimalist approach. South African courts rarely engage deeply with international law. Many international human rights norms are already incorporated into the Bill of Rights. Director of Public Prosecutions, Transvaal. Court acknowledged that Section 28(2), Best Interests of the Child, was inspired by international treaties. S. B. McWanion. Chaskalson P. emphasized that binding and non-binding international law provides a framework for Bill of Rights interpretation. Courts often cite treaties but fail to engage with the jurisprudence of international tribunals. Section 39(1)(b) expectation: courts should refer to precedents from international human rights tribunals, not just treaty texts. Key cases: Glenister v. President of South Africa and others. Section 39(1)(b) makes international law a standard for state conduct. Used international law to justify the creation of an anti-corruption unit under the Constitution. National Commissioner of Police v. Southern Africa Human Rights Litigation Center. International law compelled SAPS to investigate crimes against humanity in Zimbabwe. Court relied on African Commission findings. SADC Tribunal case. Court ruled the president violated the Constitution by supporting the SADC Tribunal's suspension. Need for a methodological approach to international law. Two categories of international law. 1. Binding sources, high weight. Ratified and domesticated treaties. Ratified but non-domesticated treaties. Customary international law. 2. Non-binding sources, lower weight. Unratified treaties. Soft law standards, for example, European Court of Human Rights jurisprudence. Courts should focus on binding obligations but can use non-binding sources persuasively. _ 11.10.4 Domestic enforcement of international decisions. No explicit constitutional/statutory framework for enforcing international court decisions in South Africa. SADC Tribunal's Campbell case highlighted the issue. Tribunal ordered Zimbabwe to pay compensation to farmers. Zimbabwe refused. Applicants sought enforcement in South African courts. Cape High Court granted enforcement via attachment of Zimbabwean assets in Cape Town. Upheld by Supreme Court and Constitutional Court. SADC Legal Framework. Article 32 of Protocol on the SADC Tribunal. 1. National laws govern enforcement of foreign judgments. 2. States must take necessary steps for execution of tribunal decisions. 3. Decisions are binding and enforceable within member states. Constitutional Court in FIC case. Found South African law lacks a specific enforcement framework for international decisions. Developed common law to allow enforcement of international court rulings. Ensured domestic enforcement of subregional justice mechanisms. _ Summary of key points. Interpretive guidance. Courts must consider international law under sections 39(1) and 233 but rarely engage deeply. Judicial reluctance. Courts cite treaties but do not extensively analyze international jurisprudence. Methodological distinction. Courts should give higher weight to binding international law but can use non-binding norms as persuasive authority. Domestic enforcement. South African law lacks a formal procedure, but courts have developed common law to enforce international decisions. Let me know if you need any refinements. Next page. Chapter 12, International Humanitarian Law, Gerhard Kemp. _ 12.1 Introduction. International Humanitarian Law, IHL, is part of public international law. Its primary aim is to humanize warfare by limiting human suffering in armed conflicts. IHL does not prohibit armed conflict but regulates the methods and conduct of hostilities. It applies equally to all parties in an armed conflict, regardless of which party initiated the conflict. IHL protects humans and property during war and is enforceable through national legal systems, international criminal law, and state responsibility mechanisms. IHL is closely linked with international criminal law and international human rights law, IHRL. _ 12.2 A brief historical overview of IHL and its sources. Ancient and medieval roots. Concepts of mercy and humanitarianism in warfare existed in ancient civilizations like Sumerians, Persians, Greeks, and medieval Christendom and Islam. Example, Sultan Saladin, 12th century, treated wounded soldiers equally on both sides of the conflict. Philosophers like Francisco de Vitoria and Hugo Grotius, De Jure Belli AC Passus, 1625, laid foundations for IHL principles. Modern development. The Geneva Conventions. Henry Dunant, Swiss humanitarian, documented war horrors in A Memory of Solferino, 1859, leading to First Geneva Convention, 1864, protection of wounded and sick soldiers. Establishment of the Red Cross emblem for protection. Hague Peace Conferences, 1899 and 1907. Extended IHL to maritime warfare and war on land. Prohibited inhumane weapons, for example, expanding bullets. Established rules for the treatment of prisoners of war in occupied territories. Geneva Convention, 1929. Improved protection for prisoners of war, based on World War I experiences. The 1949 Geneva Conventions, post-World War II, comprehensive revision and expansion of previous treaties. 4 Geneva Conventions. 1. Protection of wounded and sick in armed forces on land. 2. Protection of wounded, sick, and shipwrecked members of armed forces at sea. 3. Treatment of prisoners of war, most comprehensive, 143 articles. 4. Protection of civilians in wartime, major development due to civilians becoming primary war victims. Additional protocols to the Geneva Conventions. Protocol I, 1977, Protection of Victims in International Armed Conflicts. Protocol II, 1977, Protection of Victims in Non-International Armed Conflicts. Protocol III, 2005, introduced the red crystal as a neutral emblem alongside the Red Cross and Red Crescent. Other key sources of IHL, International Criminal Tribunal statutes, for example, ICTY, ICTR, ICC. National laws on IHL, for example, South Africa's implementation of the Geneva Conventions Act 8 of 2012. ICRC's customary international humanitarian law study. The Martens Clause, 1907. Even if a specific action is not explicitly prohibited, it may still be unlawful based on custom, humanity, and public conscience. Incorporated in Additional Protocol I, Article 1-2. _ This summary provides a structured and concise breakdown of the introduction and historical development of IHL. Let me know if you need more sections. Next. Page 12.3. The relationship between jus ad bellum and jus in bello. Jus ad bellum governs the use of force and the right of states to engage in war. Historically, war was considered a sovereign right of states before 1914. Post-World War I, shift in norms, Kellogg-Briand Pact, 1928. Outlawed war as a national policy tool. UN Charter, 1945, established modern jus contra bellum, prohibition of war, with 2 exceptions. 1. Self-defense, Article 51, UN Charter. 2. Security Council authorization under Chapter 7. Jus in bello regulates conduct in armed conflict, IHL principles. Even if force is lawful under jus ad bellum, IHL applies equally to all parties in war. The principle of equal application of jus in bello ensures adherence to IHL, even when a party is the aggressor. _ 12.4 Differentiating between international and non-international armed conflicts. IHL applies differently based on conflict classification. International armed conflict, IAC, armed force between 2 or more states, ICTY definition. Non-international armed conflict, NIAC, protracted armed violence between government forces and organized armed groups, or between such groups within a state. Geneva Conventions, 1949, primarily regulate IAC, but Common Article 3 applies to NIACs, protecting persons out of combat, for example, surrendered fighters. Prohibitions on torture, executions, and cruel treatment. Additional Protocol 2, 1977, expanded protections for NIACs. ICTY and ICTR. Violations of Common Article 3 and Additional Protocol 2 can constitute war crimes. Customary IHL. IHL norms apply in IACs even if a state withdraws from Geneva Conventions. Increasing recognition of customary IHL in NIACs. Prosecutor v. Tadek, ICTY. Changing nature of conflict. Post-World War II, conflicts increasingly internal rather than state versus state. Rome Statute, ICC, maintains the legal distinction between IAC and NIAC for war crimes prosecution. _ 12.5 Armed conflicts, armed attacks, and cyber warfare. Definition of attack in IHL, Additional Protocol I, 1977, acts of violence against the adversary, whether in offense or defense. Not all military operations qualify as attacks under IHL, analysis depends on nature and effects. Cyber warfare in IHL. Cyber warfare, the use of cyber means for military operations, Tallinn Manual. Cyber operations may be classified as cyber attacks, expected to cause injury, death, or destruction. Non-violent cyber operations, for example, espionage, Surveillance. IHL applies if cyber operations are part of an ongoing armed conflict. Independent cyber operations may trigger IHL if they cause death, injury, destruction, or significantly degrade military capabilities. Non-state actors in cyber warfare. If organized hackers launch cyber attacks against a state's military, this may lead to a NIAC classification. If the target state cannot enforce criminal law, for example, due to territorial limitations, cyber retaliation could escalate into armed conflict under IHL. This summary captures the key points from the text. Let me know if you need further refinement. Next. Page 12.6 Conduct of Hostilities, the Principles and Rules of International Humanitarian Law, IHL, Sources of IHL. Treaties, for example, Geneva Conventions, Hague Regulations, Customary International Law, ICRC Study on Customary IHL, ICRC Study on Customary IHL, 1995. Commission to identify customary IHL applicable in both international and non-international armed conflicts. Acknowledges limitations in omitting certain treaty provisions. Confirms that most Geneva Conventions provisions, including Common Article 3, and 1907 Hague Regulations are customary law. Geneva Conventions are universally ratified and legally binding. 12.6.1 The Principle of Distinction. Key distinctions in IHL. International armed conflicts, civilians versus combatants. Non-international armed conflicts, fighters versus civilians. Objects, civilian objects versus military objectives. Attacks, indiscriminate attacks prohibited. Precautionary measures, must protect civilians. 12.6.1.1 Distinction between civilians and combatants, international, and fighters and civilians, non-international, general rule. Parties to a conflict must always distinguish between civilians and combatants. Attacks may only target combatants, civilians must not be targeted. Applies to both international and non-international conflicts. Combatants, armed forces members, excluding medical and religious personnel. Civilians, those not part of armed forces or those who ceased participation. Prohibition of terror tactics against civilians. Acts or threats of violence intended to spread terror are prohibited. Applies in both international and non-international conflicts. Examples include indiscriminate shelling, city bombardment, sexual violence, rape, torture, and abuse. Definition of armed forces in IHL. Includes all organized armed forces, groups, and units under a responsible command. Unclear whether paramilitary units or police forces are included. States should clarify incorporation of such forces via legislation. Lack of formal incorporation does not preclude a finding that such forces are de facto part of armed forces. Civilians taking direct part in hostilities. Civilians lose protection if they take direct part in hostilities. No universally accepted definition of direct participation in hostilities. Generally, those contributing indirectly, for example, munitions factory workers, are still considered civilians. Non-international armed conflicts. No formal combatant status for fighters. Historically, non-state fighters were treated as criminals. Treason, murder. Common Article 3 of the Geneva Conventions and Additional Protocol 2 require humane treatment. Additional Protocol 2 distinguishes between fighters and civilians in non-international conflicts. 12.6.1.2 Distinction between civilian objects and military objectives. Attacks may only be directed at military objectives. Collateral damage issue. Urban warfare and modern weaponry complicate rule application. Precise targeting has improved but collateral damage remains controversial. Definition of military objectives. Objects contributing to military action and offering a definite military advantage. Includes targets based on nature, location, purpose, or use. Presence of civilians near military targets does not necessarily make the target immune. Dual-use objects, for example, communication facilities, may become military objectives. Presumption of civilian status in doubt. If an object's military use is uncertain, it must be presumed civilian. Additional Protocol I, Article 52.3. Examples, places of worship, homes, schools. Next. Page. Here's a structured summary of the key points from the text. 12.6.1 Indiscriminate attacks, proportionality, and precautionary measures. 12.6.1.3 Indiscriminate attacks. IHL prohibits indiscriminate attacks, which include Attacks not directed at a specific military objective. Use of methods/weapons that cannot be targeted precisely. Use of methods/weapons with uncontrollable effects, for example, biological weapons. Principle of distinction is violated in such cases. IHL prohibits bombardments that treat multiple distinct military objectives in populated areas as a single target. 12.6.1.4 Attacks must be proportional. IHL prohibits attacks causing excessive civilian harm in relation to direct military advantage. This rule applies to both international and non-international armed conflicts. Proportionality is assessed based on the overall military advantage, not isolated incidents. 12.6.1.5 Precautionary measures. Military operations must minimize civilian harm through feasible precautions, including advance warnings when possible, ensuring targets are military objectives, choosing methods that minimize civilian damage. If a target is misidentified or civilian damage becomes excessive, the attack should be suspended. Conflict parties must take feasible precautions to protect civilians under their control. Avoid locating military objectives near civilian areas, for example, refugee camps. _ 12.6.2 Specifically protected persons and objects. 12.6.2.1 Medical and religious personnel. Medical personnel assigned exclusively to medical duties must be respected and protected. They lose protection if they engage in harmful acts outside their duties. This protection dates back to the Geneva Convention of 1864 and applies in international and non-international conflicts. Civilian medical personnel are also covered. Targeting medical personnel with Geneva Convention emblems may lead to criminal liability. Medical personnel definition: those exclusively assigned to care for the wounded/sick, prevent disease, or operate medical units/transports. IHL prohibits punishing medical personnel for ethical medical duties, forcing them to act against medical ethics. Religious personnel exclusively assigned to religious duties are also protected. Protection is lost if they engage in hostile acts. Difficult to define and recognize in conflict settings. 12.6.2.2 Humanitarian relief personnel and objects. Humanitarian relief personnel must be protected and respected. Applies in both international and non-international conflicts. Armed forces delivering humanitarian aid are not covered by this rule. UN and associated humanitarian personnel are protected under the Convention on the Safety of United Nations and Associated Personnel, 1994. Humanitarian relief objects/supplies are treated as civilian objects and must not be attacked. 12.6.2.3 Peacekeeping personnel and objects. UN and regional peacekeepers, for example, African Union, are protected as civilians under IHL. Protection is lost if they directly participate in hostilities. Peacekeepers are also protected under the 1994 Convention on the Safety of United Nations and Associated Personnel. UN is not a party to the Geneva Conventions but generally adheres to IHL principles. Legal status of IHL obligations for peacekeepers depends on UN mandates and agreements with host states. Level of peacekeeper involvement in conflict. If peacekeepers actively engage in combat, customary IHL rules likely apply to them. UN has a political and normative commitment to uphold IHL principles. Next page. Summary of 12.6.2 to 12.6.3, Protection of certain persons, places, and methods of warfare in IHL. 12.6.2 Protection of certain persons and places. Journalists. Civilian journalists covering armed conflicts must be respected and protected unless they take direct part in hostilities. War correspondents, though civilians, accompany armed forces and are entitled to prisoner of war status upon capture. Geneva Convention 3. Protected zones. Prohibition on attacking zones that shelter wounded, sick, and civilians, such as hospitals and safety zones, away from conflict areas. Neutralized zones, within conflict areas. Attacks on demilitarized zones, areas agreed not to be occupied for military purposes, are prohibited. Civilian areas, villages, towns, suburbs, are protected under Hague Regulations, Additional Protocol I, and Geneva Conventions. Targeting undefended civilian places constitutes a war crime. Cultural property. IHL protects buildings, artifacts, and cultural heritage sites. Hague Convention 1954 mandates marking such property with a blue and white distinctive shield, figure 12.3. Parties must avoid damage to religious, artistic, scientific, educational, and charitable buildings unless a military necessity. Prohibit seizure, destruction, vandalism, theft, or pillaging of cultural property. Preventing return illicitly exported cultural property from occupied territories. Dangerous works and installations. Attacks on dams, dikes, nuclear stations, and other hazardous facilities must avoid releasing dangerous forces, for example, floods, nuclear fallout. Some states justify attacks based on proportionality and military necessity. The natural environment. Military versus civilian targets distinction applies to the environment. Prohibited. Attacking natural environments unless a military objective. Excessive destruction unless imperative military necessity. Rome Statute criminalizes attacks causing widespread, long-term, and severe damage to the environment. Some states, for example, U.S., UK, France, reject IHL's environmental protection norms, especially concerning nuclear weapons. 12.6.3 Methods of Warfare. Denial of quarter. Prohibition on declarations that no quarter will be given, i.e., no survivors. Attacking persons or to combat, i.e., captured, unconscious, wounded, surrendered, is prohibited unless they resume hostilities or attempt to escape. Destruction and seizure of property. General prohibition on destroying or seizing enemy property, except under imperative military necessity. Seizure of military equipment is allowed. Pillaging, looting private property, is strictly prohibited in international and non-international conflicts. Starvation and access to humanitarian relief. Starvation of civilians as a method of warfare is prohibited. Prohibited, attacking or destroying objects essential for civilian survival, for example, food, water, medicine. Exception, if objects sustain combatants exclusively, they can be targeted. Scorched earth policy, destroying territory to deprive enemy resources, is likely still legal in international conflicts, but doubtful in non-international conflicts. Humanitarian aid must be allowed, denial must not be arbitrary. Deception. Ruses of war, misleading tactics, are allowed unless they violate IHL rules. Prohibited forms of deception. Misuse of white flag of truce. Misuse of Red Cross and other Geneva Convention emblems. Unauthorized use of UN emblem and uniform. Misuse of protected emblems, for example, cultural property shield, enemy or neutral state flags. Perfidy, treacherous deception, is prohibited. Faking injuries or surrender to lure the enemy. Misusing protective emblems, for example, Red Cross. Pretending to be a civilian. Communication with the enemy. Commanders can communicate with the enemy for military or humanitarian reasons, for example, humanitarian aid, evacuations, demilitarized zones. Contact must be in good faith and can occur through any means. White flag of truce is commonly used for such communication. This summary encapsulates key IHL rules regarding the protection of persons and places and the methods of warfare, focusing on prohibitions, protections, and exceptions. Next page. 12.6.4 The use of certain types of weapons. 12.6.4.1 General principles for the use of weapons. IHL does not prohibit war but aims to limit human suffering by regulating warfare. Weapons are not generally prohibited, but certain norms restrict their use. Key principles governing weapon use. Prohibition of means and methods that cause superfluous injury or unnecessary suffering. Applicable to international and non-international armed conflicts via treaties such as Hague Regulations, Additional Protocol I, API, Rome Statute of the ICC, Ottawa Convention, Anti-Personnel Mines, Convention on Certain Conventional Weapons, CCW, and Amended Protocol II. Debate on whether certain weapons are illegal per se or only in specific uses. Weapons identified as causing unnecessary suffering. Lances/spears with barbed heads. Serrated-edged bayonets. Expanding and explosive bullets. Poison weapons. Biological and chemical weapons. Certain booby traps. Anti-personnel mines. Blinding laser weapons. Weapons that are indiscriminate by nature are prohibited. Principle of distinction. Examples: chemical weapons, biological weapons, cluster bombs. Article 36 of API mandates states to review new weapons for legality. Based on the St. Petersburg Declaration, 1868, balancing war necessities with humanity. 3-step review. 1. Check for specific treaty/customary law prohibiting the weapon, for example, poison, biological weapons. 2. Assess compatibility with API and customary IHL, focus on unnecessary suffering, indiscriminate behavior, long-term environmental damage. 3. Consider the Martens Clause, Principles of Humanity and Dictates of Public Conscience. Emerging Concerns. Autonomous Weapon Systems, AWS. AWS differs from automated systems, drones. AWS can target and initiate lethal force without human supervision. Key issues. IHL compatibility. AWS may not satisfy distinction and proportionality principles. Accountability. Lack of moral agency makes assigning criminal responsibility difficult. Command responsibility concerns. AWS challenges existing liability frameworks. Ethical objections. Allowing machines to decide on life and death contradicts human morality. AWS and International Human Rights Law, IHRL. IHRL protects all human life and demands precise targeting. AWS unlikely to comply. Deadly force under IHRL must be highly individualized and restrictive. Need for a new legal framework if AWS use becomes inevitable. 12.6.4.2 Nuclear weapons. Nuclear weapons are highly destructive and indiscriminate, raising legal and ethical concerns. ICJ Advisory Opinion, 1996, on nuclear weapons. General use or threat violates IHL principles. Uncertainty remains regarding extreme self-defense cases. Article 51, UN Charter. Treaty on the Prohibition of Nuclear Weapons, TPNW, 2017. Prohibits participation in nuclear weapon activities, including development, testing, production, acquisition, possession, stockpiling, use, or threat of use. Obligates states to prevent prohibited activities within their jurisdiction. Not yet in force. Challenges. Resistance from nuclear armed states makes complete disarmament unlikely in the near future. Next page. Study notes on international humanitarian law, IHL 12.6.4.3 Biological and chemical weapons. International prohibitions. Biological weapons. Biological Weapons Convention and Geneva Gas Protocol prohibit use in international armed conflicts. Prohibition extends to non-international armed conflicts due to widespread condemnation. UN General Assembly resolutions emphasize strict compliance. Chemical weapons. Geneva Gas Protocol, Chemical Weapons Convention, and Rome Statute of the ICC prohibit use in international armed conflicts. Chemical Weapons Convention prohibition extends to non-international armed conflicts. Rome Statute amendments. Kampala Review Conference, 2010, proposal to amend Article 8 of the Rome Statute to include war crimes for using certain poisonous weapons, asphyxiating/poisonous gases in non-international armed conflicts. ASP meeting, 2017. Adopted amendments criminalizing use of microbial/biological agents, toxins, and analogous materials in all armed conflicts. 12.6.4.4 Expanding bullets. Prohibition under IHL. Expanding or flattening bullets violate IHL principles against superfluous injury and unnecessary suffering. Hague Declaration, 1899, first treaty banning expanding bullets in international armed conflicts. Rome Statute, Article 8. Classifies use of expanding bullets as a war crime in international armed conflicts. Kampala Review Conference, 2010, extended prohibition to non-international armed conflicts. 12.6.4.5 Anti-personnel mines. Humanitarian concerns. Mines cause severe civilian casualties and remain dangerous post-conflict. Ottawa Convention, 1997. Entered into force in 1999. Aims to eliminate anti-personnel mines globally. Underscore. 12.7 Protected persons and the Law of Geneva. Key distinction. IHL has two major components. Conduct of hostilities, regulation of warfare. Law of Geneva, protection of conflict victims. Core legal framework. 4 Geneva Conventions, 1949, and additional protocols, 1977, govern the protection of 1. Wounded and sick armed forces in the field. 2. Wounded, sick, and shipwrecked at sea. 3. Prisoners of war. 4. Civilians. Focus, protection of victims through detailed legal provisions. 12.7.1 The grave breaches regime. Definition and obligation. Grave breaches equals most serious violations of the Geneva Conventions. States must exercise universal jurisdiction over grave breaches. Rome Statute, war crimes under Article 8. Recognizes grave breaches as war crimes. 1. Willful killing. 2. Torture/inhuman treatment, including biological experiments. 3. Willfully causing great suffering or serious injury. 4. Extensive destruction of property, not justified by military necessity. 5. Compelling POWs to serve a hostile power. 6. Willfully depriving POWs of a fair trial. 7. Unlawful deportation, transfer, or confinement. 8. Taking hostages. Additional grave breaches, Protocol I, not in Rome Statute. 1. Attacking installations with dangerous forces, knowing excessive civilian harm will result. 2. Unjustified delay in repatriation of POWs or civilians. 3. Apartheid and inhuman practices based on racial discrimination. Enforcement mechanism. Universal jurisdiction, any state can prosecute perpetrators. National legislation, Geneva Convention states must criminalize war crimes. State cooperation, required for extradition and enforcement. 12.7.2 Common Article 3. Scope. Applies to non-international armed conflicts, unlike grave breaches regime. Sets minimum humanitarian standards for all conflict parties. Legal status. Considered a convention in miniature. Use by ICTY as a minimum protection standard in both international and non-international conflicts. Supplemented by additional Protocol 2 for non-international conflicts. _ These study notes summarize key legal provisions concerning weapons prohibitions, protected persons, and the enforcement of international humanitarian law. Let me know if you need additional elaboration or references. Next. Page 12.8 Enforcing the rules of IHL. States party to IHL treaties must either directly apply treaty provisions or incorporate them into domestic law. Many IHL rules have gained customary international law status and can be enforced in domestic courts. States have a general obligation to investigate and prosecute war crimes committed by their nationals or on their territory. National laws may provide for broader extraterritorial or universal jurisdiction. IHL enforcement aims at both prevention, for example, ICRC efforts, and accountability. State or individual responsibility. Shift from state liability to individual criminal liability due to developments in international criminal law, for example, ICC, ICTY, ICTR. 12.8.1 Enforcement at the national level. States must implement treaty obligations into domestic law. Example, South Africa's implementation of the Geneva Conventions Act 8 of 2012. Incorporates Geneva Conventions and additional protocols into domestic law. Criminalizes grave breaches and protects ICRC-related emblems/signs. Rome Statute Implementation Act 27 of 2002. Incorporates Rome Statute crimes into South African law, genocide, war crimes, and crimes against humanity. Provides universal jurisdiction for all war crimes under Article 8 of the Rome Statute. Geneva Conventions Act is narrower, covering only grave breaches under universal jurisdiction. 12.8.2 Enforcement in international criminal tribunals. IHL violations are also prosecuted in international criminal tribunals. Post-World War II tribunals. Nuremberg Tribunal, applied 1929 Geneva Conventions and 1907 Hague Convention but relied on Article 6 of the Nuremberg Charter for war crimes prosecution. Tokyo Tribunal, focused on crimes against peace, while war crimes were prosecuted in national military courts. Post-Cold War tribunals. ICTY, 1993, jurisdiction over grave breaches of Geneva Conventions and violations of war laws. ICTR, 1994, jurisdiction over violations of Common Article 3 and Additional Protocol 2, focused on non-international conflicts. Special Court for Sierra Leone, jurisdiction over war crimes, including attacks on peacekeepers and child soldier recruitment. International Criminal Court, ICC, established by Rome Statute, 1998, operational 2002. Jurisdiction over genocide, crimes against humanity, and war crimes. Article 8 of the Rome Statute categorizes war crimes as grave breaches of the Geneva Conventions, serious violations in international armed conflict, violations of Common Article 3, serious violations in non-international armed conflicts. 12.8.3 State responsibility for IHL violations. States can be held accountable for IHL breaches through actions or omissions of state organs, executive, military, etc. ICJ case, armed activities on the territory of the Congo, DRC v Uganda. Uganda held liable for UPDF's conduct in the DRC. State responsibility applies even if soldiers exceed orders. Article 3 of the 1907 Hague Convention and Article 91 of Additional Protocol I. A state is responsible for all acts committed by its armed forces. Attribution of responsibility for paramilitary groups. ICJ case, Nicaragua v. USA. USA not liable for actions of Nicaraguan rebels unless it had effective control over them. Other courts argue for a broader overall control test. State liability can result in reparations or proportional countermeasures. Underscore 12.9 IHL and human rights. IHL and IHRL are distinct but related legal frameworks protecting human dignity. ICJ and legal consequences of the construction of a wall, occupied Palestinian territory. Both IHL and human rights law apply in armed conflict and occupation. Historical development of IHL and human rights link. Geneva Conventions, 1949, do not explicitly mention human rights. Tehran Resolution, 1968, called for human rights application in war. Jean Pictet, ICRC, argued that IHL provided a stronger framework for human rights than non-binding human rights instruments. ICRC concerns. Feared human rights application in IHL might imply civilian protection against their own governments, a sensitive issue. Geneva Conventions included key human rights protections in war. Right to a fair trial, for civilians, freedom of religion. Legal counsel for POWs. Right to an interpreter. POW communication with protecting powers. Right of appeal for POWs. Principles of non-discrimination and human dignity. Recognition of the right to have rights. These notes provide a structured and detailed overview of the enforcement mechanisms of IHL, including national and international enforcement, state responsibility, and the relationship between IHL and human rights. Let me know if you need any modifications. Next. Page 12.9.2 A conceptual framework for the optimal interaction between human rights and IHL, Geneva Conventions drafting history. Various attempts were made to integrate human rights into IHL, especially regarding civilian and POW protections. Some states resisted this to prevent civilians from enforcing rights against their governments or colonial powers. Complementarity of IHL and IHRL. IHL and IHRL contain cross-references, showing a complementary protection system during peacetime and armed conflict. Recognized judicially as a framework ensuring maximum human rights protection. Distinctions between IHL and IHRL. Despite complementarity, conflicts can arise, requiring prioritization of applicable rules. Some rules may be silent on certain matters, necessitating an interpretation. Macro versus micro-level analysis. Macro-level, broad comparison, both protect individuals from state action. Micro-level, case-specific application, determining which body of law applies best to particular rights/duties. Finding common ground is the general approach, but not always possible. Systemic integration and the lex specialis principle. Systemic integration. International law is a unified legal system, recognized under the Vienna Convention on the Law of Treaties. IHL and IHRL should be viewed as a normative context for each other rather than separate legal spheres. Lex specialis principle. When general and specific norms govern a matter, the specific rule prevails. ICJ recognition, applied in nuclear weapons case, where IHL determined the scope of IHRL's right to life. Some argue IHL and IHRL are competing rather than conflicting, making lex specialis less relevant. ICJ's approach in the nuclear weapons case ruled that IHL defines the standard for arbitrary deprivation of life during armed conflict. While appearing to use lex specialis, the court actually applied systemic integration by interpreting IHRL through IHL. This approach avoids binary choices and ensures both bodies of law function harmoniously. This section outlines the evolving relationship between IHL and IHRL, emphasizing their complementarity, challenges in application, and legal principles used to reconcile them. Next. Page. International Criminal Law. Christopher Jevers and Gerhard Kemp. 13.1 What is international criminal law? Emerged after World War II with the Nuremberg trials. Stagnated during the Cold War, revived in the 1990s with ad hoc tribunals, Yugoslavia, Rwanda. Establishment of the International Criminal Court, ICC, 1998. Debate over its scope. Core crimes, genocide, crimes against humanity, war crimes, aggression. Some scholars argue for broader definitions, for example, terrorism, torture. Defined as the prosecution of core international crimes by domestic or international courts. 13.2 The core international crimes 4 core crimes prosecuted under ICL. War crimes. Crimes against humanity. Genocide. Aggression. 13.2.1 War crimes. Rooted in international humanitarian law, IHL. Codified in the 1899-1907 Hague Conventions and 1949 Geneva Conventions. Must occur during armed conflict. International armed conflict, between two or more states. Non-international armed conflict, between a state and non-state actors. Types of war crimes. Crimes against persons, murder, torture, sexual violence, use of child soldiers. Crimes against property, attacks on religious, cultural, and medical sites. Prohibited methods of warfare, starvation, hostage-taking. Prohibited weapons, those causing unnecessary suffering. 13.2.2 Crimes against humanity. Introduced at Nuremberg for Nazi atrocities against civilians. Key elements. Inhumane acts against civilians must be widespread or systematic. Significant changes since 1946. No longer requires an armed conflict. Genocide became a separate crime. Expanded list of crimes, now 15 under the Rome Statute. 13.2.3 Genocide. Coined by Raphael Lemkin, criminalized in the 1948 Genocide Convention. Special intent requirement, dolus specialis. Acts must be committed with intent to destroy a group. Protected groups, national, ethnic, racial, religious, no social or political groups. Must involve physical or biological destruction. More specific than crimes against humanity, limited to 5 acts. 13.2.4 Aggression. First criminalized post-World War I, Treaty of Versailles. Defined at Nuremberg as the supreme international crime. Codified in UN Charter, Article 2.4. Prohibiting use of force. Jurisdiction under ICC since 2017, complicated enforcement. 13.3 The history of international criminal law. Nuremberg and Tokyo tribunals, post-World War II. Cold War stagnation. Revival in 1990s. ICTY, Yugoslavia, ICTR, Rwanda. Rome Statute, 1998, permanent ICC. 13.4 Enforcing international criminal law. 13.4.1 The International Criminal Court, ICC, jurisdiction. Genocide, crimes against humanity, war crimes, aggression. Applies when states are unwilling/unable to prosecute domestically. Triggering ICC jurisdiction. State referral, Security Council referral, or prosecutors proprio motu action. Admissibility. Complementarity, ICC only acts if national courts fail. Gravity. Crime must be of serious magnitude. State cooperation. Rome Statute mandates state assistance in arrests, evidence gathering, and extraditions. 13.4.2 International criminal law in South Africa. Domestic enforcement mechanisms. Rome Statute Implementation Act, 2002. Geneva Conventions Act, 2012. Direct application of customary international law. Notable cases. Bassan cases, apartheid-era crimes. Salk cases, universal jurisdiction efforts. 13.4.3 South Africa's future in international criminal law. Debate over continued ICC membership. Political tensions, for example, al-Bashir case. Potential withdrawal from ICC, but legal obligations remain. _ This condensed version keeps all critical legal aspects while reducing length. Let me know if you need adjustments. Next page. Here's a detailed and structured summary of the provided text. _ 13.3 The history of international criminal law. The history of international criminal law, ICL, is complex and lacks a unifying theory. Some scholars trace its origins back to antiquity, while others link it to the establishment of the International Criminal Court, ICC. Early examples include the international prohibition on piracy, offenders as hostis humanis generis, enemies of all mankind. The 19th century prohibition of slavery. Early 20th century developments. Treaty of Versailles, 1919, considered an early normative expression of modern ICL. Called for the prosecution of Emperor William II of Germany for a supreme offense against international morality and the sanctity of treaties. Recognized the right of the Allies to prosecute individuals for war crimes. Proposed a special tribunal to try accused persons, though never implemented due to the Netherlands' refusal to extradite William II. Leipzig trials, 1921, held in the German Supreme Court but were limited, with only 12 out of 900 accused tried. Nuremberg and post-World War II developments. Nuremberg Trials, 1945-46, conducted by the International Military Tribunal, IMT, to prosecute Nazi leaders for war crimes, crimes against humanity, and crimes against peace. 24 German leaders were indicted, 21 tried, 12 sentenced to death. Control Council Law No. 10 trials, conducted by the U.S. military in occupied Germany. International Military Tribunal for the Far East, Tokyo Trials, 1946, modeled on Nuremberg but faced criticisms due to lack of legal standards. Cold War stagnation and later revival. Initial progress post-World War II. Nuremberg Principles, 1946. Genocide Convention, 1948. Geneva Conventions, 1949. Introduced grave breaches regime. Cold War hindered progress. Efforts to establish a permanent international criminal tribunal stalled. Genocide Convention, 1948, included a resolution to create an international judicial organ, but work ceased in 1954. Notable exceptions. Apartheid Convention, 1974, criminalized apartheid as a crime against humanity. Domestic trials of Nazi war criminals, for example, Adolf Eichmann in Israel, Klaus Barbie in France. Post-Cold War developments. 1989, UN General Assembly revisited the idea of an international criminal court following a Trinidad and Tobago proposal concerning transnational crimes. 1990s Renaissance in ICL. Establishment of international criminal tribunals. International Criminal Tribunal for the Former Yugoslavia, ICTY, 1993. International Criminal Tribunal for Rwanda, ICTR, 1994. Introduction of hybrid tribunals. Sierra Leone, Cambodia, Lebanon, East Timor. 1994, International Law Commission, ILC, drafted a statute for an international criminal court. 1998 Rome Statute. Established the ICC, which can prosecute genocide, crimes against humanity, war crimes, and aggression, aim, and impunity for the perpetrators of serious international crimes. The ICC's structure reflects compromises due to diverse state interests. _ 13.4 Enforcing international criminal law, international and domestic prosecutions. ICL is enforced by both international and domestic courts. International courts, for example, ICC, rely on states for arresting suspects, extradition/surrender for trial, imprisonment post-conviction. Domestic courts enforce international law through universal jurisdiction cases. Domestic prosecutions in ICL, historically significant domestic trials. Leipzig Trials, post-World War I. Control Council Law 10 Trials, post-World War II. Many international law principles originated from domestic legal systems. Treaties often mandate national prosecutions of international crimes. South African Constitutional Court in SB Bassan affirmed that domestic courts retain jurisdiction over international crimes. ICC and complementarity. 1998 Rome Statute institutionalized the principle of complementarity. ICC has jurisdiction only if domestic courts are unwilling/unable to prosecute. Encourages domestic prosecutions while keeping ICC as a last resort. Since 1998, many states have adopted legislation to prosecute core international crimes. African Union, AU, model law on universal jurisdiction aids African states in prosecuting international crimes. _ 13.4.1 The International Criminal Court, ICC. ICC was established in 1998 and became operational in 2002. Jurisdiction over genocide, crimes against humanity, war crimes, from July 2002. Crime of aggression, from July 2018. ICC Headquarters, The Hague, Netherlands. 124 states have ratified the Rome Statute. Burundi withdrew, 2017. Malaysia joined, 2019. Rome Statute functions. 1. Defines ICC's structure, powers, and functions. 2. Establishes state cooperation requirements for investigations and prosecutions. 3. Principle of complementarity, Articles 1, 17. States have primary jurisdiction over crimes. ICC steps in only if national courts fail. Prevents states from shielding offenders. Challenges and criticism. Tensions with African states due to 1. Cases against high-profile African leaders, al-Bashir, Kenyan politicians. 2. Failure to prosecute non-African cases. 3. Abuse of universal jurisdiction by European states. Perceived ICC bias against African nations. ICC jurisdiction requirements. 1. Crime must fall within ICC's jurisdiction. 2. Jurisdiction must be triggered by the ICC prosecutor, by a state party, by the UN Security Council. 3. Case must meet admissibility criteria, gravity and complementarity. Types of ICC jurisdiction. 1. Subject matter jurisdiction, ratione materiae. Genocide, war crimes, crimes against humanity, aggression. 2. Temporal jurisdiction. Crimes after July 1, 2002, except aggression, after July 17, 2018. 3. Personal jurisdiction, ratione personae. Applies to individuals, not states. _ This summary provides a structured, bullet point overview of the key points from the provided text while maintaining its depth and comprehensiveness. Let me know if you need any modifications or further details. Next page. Here's a detailed summary of the provided text in bullet point format. _ 13.4.1.2 How cases come before the ICC. Jurisdiction alone is insufficient for a case to be heard by the ICC, it must first be triggered and pass the admissibility test. 13.4.1.2.1 Triggering the court's jurisdiction. The ICC's jurisdiction can be triggered in 3 ways under the Rome Statute. 1. State party referrals, Article 14. States parties can refer situations where core crimes appear to have been committed. The ICC can only act if crimes were committed in a state party's territory. Crimes were committed by nationals of a state party. A non-state party consents ad hoc to ICC jurisdiction. Self-referrals are the most common, for example, Uganda, DRC, CAR, Mali. 2. Prosecutor-initiated investigations, Article 15. The prosecutor may initiate investigations proprio motu, on their own accord, with pretrial chamber approval. Approval is granted if there is a reasonable basis to proceed and jurisdiction exists. Kenya's post-2007 election violence was the first case initiated this way. 3. UN Security Council referrals, Article 13b. Security Council referrals simultaneously trigger an established jurisdiction, used for Darfur, Sudan, and Libya, neither of which are ICC member states. 13.4.1.2.2 The admissibility of situations and cases. Jurisdiction does not guarantee prosecution, cases must be admissible. Admissibility is an ongoing assessment and can be challenged at the preliminary stage, before case identification, by an accused, an interested state, or the court before/during trial. 3 grounds for admissibility challenges. 1. Complementarity, Article 17. Cases are inadmissible if they are being investigated/prosecuted by a state unless the state is unwilling, for example, shielding suspects, unable, for example, no functioning legal system. 2. Gravity-based challenges. Cases lacking sufficient gravity are inadmissible. The prosecutor's quantitative approach focuses on victim numbers. Heller's qualitative approach suggests considering systematic crimes based on policy/plan, crimes causing social alarm internationally, state-perpetrated crimes rather than rebel actions. 3. Non bis in idem, double jeopardy, challenges, Article 20. A case is inadmissible if the accused has already been tried for the same conduct. Exceptions: the previous trial aimed to shield the accused or lacked due process. Only applies to specific cases, not general situations. _ 13.4.1.3 State cooperation under the Rome Statute. The ICC lacks direct enforcement power, relying on state cooperation. The Rome Statute Part 9 balances horizontal cooperation, weaker, interstate model, vertical cooperation, stronger, suprastate model, like ad hoc tribunals. Obligations of states under the Rome Statute. Article 86. General obligation to fully cooperate with the ICC. States must ensure national legal procedures facilitate cooperation. Execution of arrest warrants. States must arrest suspects on their territory upon ICC request. Other cooperation duties include identifying suspects and locating evidence, taking and producing evidence, including expert reports, interrogating suspects and witnesses, serving legal documents, facilitating witness/expert testimony, conducting site inspections, exhumations, executing searches, seizures, and asset tracing, protecting victims and witnesses, enforcing ICC sentences, equitable state distribution. Consequences of non-compliance. If a state refuses to cooperate, the ICC may refer the matter to the Assembly of States Parties, the UN Security Council, for Security Council referrals. _ South Africa's cooperation with the ICC. South Africa's ICC cooperation is governed by the implementation of the Rome Statute Act 27 of 2002, ICC Act. Chapter 4 of the ICC Act. Cooperation duties, arrest, surrender, judicial assistance, penalties for obstructing justice. Arrest and surrender procedure, Section 8 of ICC Act 1. ICC requests an arrest warrant execution. 2. Director General of Justice reviews the request and submits it to a magistrate. 3. Magistrate endorses the ICC warrant, allowing arrest anywhere in South Africa. 4. Suspect appears before a magistrate, who ensures identity verification. Legal arrest procedures were followed. Rights under the Bill of Rights were respected. 5. Committal order issued for surrender to The Hague. Differences between ICC surrender and extradition. ICC surrender does not equal extradition. No double criminality requirement. No prima facie case requirement. South Africa's failure to arrest Omar al-Bashir, 2015. South Africa failed to arrest Sudanese President Omar al-Bashir, indicted for war crimes, crimes against humanity, and genocide. Minister of Justice v Southern Africa Litigation Center, SCA decision, 2016. South Africa violated its obligations under the Rome Statute, the ICC Act, the South African Constitution. The ICC Act removes head of state immunity for ICC crimes. ICC Pretrial Chamber 2, 2017 decision on South Africa's non-cooperation. Article 98(1), head of state immunity, did not apply because Sudan, a UN member, had obligations under Security Council Resolution 1593. Sudan should be treated as an ICC state party for enforcement purposes. Kenya's Court of Appeal, 2018, Attorney General v ICJ Kenya. Kenya failed to arrest al-Bashir despite ICC arrest warrants. Following the South African precedent, Kenya's courts ruled that al-Bashir had no immunity for ICC crimes. Kenya had a legal duty to arrest and surrender him. _ Additional Cooperation Measures, ICC Act, Part 2 and Section 6, Article 88 of the Rome Statute and ICC Act Part 2. Requires authorities to cooperate with ICC investigations/prosecutions. Section 6 of the ICC Act. The South African President may declare a location in South Africa as the seat of the ICC, if requested. State cooperation in sentence enforcement. States assist in enforcing ICC prison sentences. _ This structured summary retains essential details while condensing the content. Let me know if you need any refinements. Next page. Here are your detailed study notes on the enforcement of international criminal law in South Africa. International Criminal Law SA 13.4.2 The enforcement of international criminal law in South Africa. Definition: prosecution of international crimes by both international and domestic courts. Principle of complementarity. The Rome Statute recognizes domestic courts as key in prosecuting international crimes to end impunity. Domestic implementation. Many states have adopted laws to criminalize international crimes and prosecute them domestically. South Africa's legislative approach combines international obligations with domestic legislation, ensures alignment with the ICC while maintaining domestic jurisdiction over international crimes. Legal distinction. Domestic prosecutions rely on state jurisdiction under international law, whereas ICC prosecutions follow the Rome Statute. South Africa's legislative measures. ICC Act, 2002, implements the Rome Statute, providing for domestic prosecution of genocide, war crimes, and crimes against humanity. Geneva Conventions Act, 2012, implements the 1949 Geneva Conventions and their protocols, granting jurisdiction over grave breaches. Constitution. Customary international law applies directly in South African courts, offering a third avenue for prosecution. 13.4.2.1 The implementation of the Rome Statute of the International Criminal Court Act 27 of 2002. Purpose: 1. Establish a cooperative framework with the ICC, Article 88 of the Rome Statute. 2. Enable domestic prosecution of international crimes within South African courts. Key provisions. Section 4.1. Any person committing an international crime is guilty of an offense, regardless of conflicting laws. Incorporation of Rome Statute crimes, genocide, war crimes, and crimes against humanity are integrated into South African law. Jurisdictional grounds. Territoriality, crimes committed within South Africa. Nationality, crimes committed by South African citizens or residents. Passive personality, crimes against South African victims. Universal jurisdiction, crimes committed outside South Africa by non-nationals, provided the suspect is present in South Africa post-crime. Constitutional Court ruling. Universal jurisdiction is permitted under international law. Investigations can commence even if the suspect is not present in South Africa. Immunity considerations. ICC Act provisions, removes personal immunity for state officials accused of international crimes. Constitutional override, customary international law applies only if consistent with the Constitution and Acts of Parliament. Prosecution process. National Director of Public Prosecutions, NDPP, approval, required before prosecuting international crimes. Referral to ICC, if the NDPP declines prosecution, reasons must be forwarded to the ICC. Priority Crimes Litigation Unit, PCLU. Manages and directs investigations, issues arrest warrants and proceeds with prosecution in designated high courts. Trial and sentencing, no specific procedure or sentencing guidelines, defaulting to standard criminal procedures. 13.4.2.2 The implementation of the Geneva Conventions Act 8 of 2012. Purpose. 1. Incorporate the Geneva Conventions and Protocols into domestic law. 2. Prevent and punish grave breaches of the Geneva Conventions. Key provisions. 2 categories of crimes. Grave breaches, serious war crimes and international armed conflicts. Other offenses, violations of Geneva Conventions, including those in non-international armed conflicts. Jurisdictional regimes. Grave breaches, subject to universal jurisdiction, without requiring the suspect's presence in South Africa. Other offenses, subject to territoriality and nationality jurisdiction, excludes passive personality jurisdiction. Retrospective application, Section 7.4. Allows prosecution of breaches occurring before the Act's enactment. Ambiguity regarding its interpretation could be seen as a retrospective application clause or recognition of pre-existing customary international law obligations. Modes of liability. Direct perpetration, Section 5. Command responsibility, Section 6. Holds military superiors accountable for breaches by subordinates. Requires knowledge or reasonable foresight of the breach. Imposes responsibility for failing to prevent, suppress, or report violations. Conclusion. South Africa's framework. Although yet to prosecute any individual for international crimes, the legislative framework places South Africa at the forefront of domestic prosecution efforts. Judicial interpretation and implementation. Ongoing judicial clarification is required to resolve ambiguities in the application of these laws. Your study notes on the enforcement of international criminal law in South Africa are ready. Let me know if you need any modifications or additional details. Next. Always show and chat. Page 13.4.2 The enforcement of international criminal law in South Africa. Definition: International criminal law, ICL, involves the prosecution of international crimes by both international and domestic courts. Domestic versus international prosecution. Domestic courts are crucial to ICL's goal of ending impunity, as per the Rome Statute's principle of complementarity. Many states, including South Africa, have enacted domestic laws to criminalize international crimes and allow their prosecution. South Africa has merged its implementation of the Rome Statute with domestic laws, leading to legal complexities. Legal distinction. Domestic prosecution relies on traditional state jurisdiction under international law. ICC prosecution is based on the Rome Statute. 13.4.2.1 Implementation of the Rome Statute of the International Criminal Court Act 27 of 2002, ICC Act. South Africa ratified the Rome Statute on November 27, 2000 and enacted the ICC Act in 2002. Main objectives. 1. Cooperation with the ICC, as per Article 88 of the Rome Statute. 2. Domestic prosecution of core international crimes, genocide, crimes against humanity, war crimes, excluding the crime of aggression. Key provisions. Section 4.1, International crimes, genocide, crimes against humanity, War crimes are criminal offenses under South African law. Rome Statute's definitions of crimes are incorporated into domestic law. Modes of liability from the Rome Statute are not included. Courts must apply domestic equivalents, for example, aiding and abetting, common purpose doctrine. Jurisdiction grounds. Territoriality, crime committed in SA. Nationality, accused or victim is a South African citizen or ordinarily resident. Passive personality, victim is a South African citizen. Universal jurisdiction, crime committed outside SA, but the suspect is later found in SA, Section 43C. Universal jurisdiction and presence requirement. Constitutional court ruling. SA courts can investigate crimes under universal jurisdiction without suspect's presence. Universal jurisdiction is permitted under international law. Immunity issues. ICC Act removes personal immunity for state officials accused of international crimes. Section 232 of the Constitution, customary international law applies unless inconsistent with the Constitution or an Act of Parliament, for example, ICC Act. Prosecution procedure. Consent of National Director of Public Prosecutions, NDPP, required before prosecution. If prosecution is declined, reasons must be sent to the Registrar of the ICC. Priority Crimes Litigation Unit, PCLU, handles ICC Act cases. High courts designated to hear cases, but trial procedures follow standard criminal trial rules. 13.4.2.2 Implementation of the Geneva Conventions Act 8 of 2012. Adopted in 2012, 60 years after SA acceded to the 1949 Geneva Conventions. Purpose. 1. Enact the Geneva Conventions and Protocols into SA law. 2. Ensure prevention and punishment of grave breaches. Key provisions. Annexes full Geneva Conventions to the Act, making them legally binding in SA. Establishes a war crimes regime for prosecuting breaches. Categories of offenses. Grave breaches, war crimes and international armed conflicts, for example, willful killing, torture, inhumane treatment. Other offenses includes breaches committed in non-international armed conflicts, Common Article 3 and Additional Protocol 2. Jurisdictional rules. Grave breaches, subject to universal jurisdiction, no presence requirement. Other offenses, subject to territoriality and nationality jurisdiction, not passive personality. Retrospectivity clause, Section 7.4. Allows prosecution of breaches under customary international law committed before the Act. Unclear whether this allows retrospective application of the Act itself. Modes of liability. Section 5. Direct perpetration. Section 6. Command responsibility. Superior officers liable if they knew, or should have known, about war crimes but failed to prevent/punish them. Applies to both grave breaches and ordinary breaches. Includes failure to take action or report offenses to competent authorities. Conclusion. South Africa has progressive legislation for prosecuting international crimes. Despite this, no prosecutions have taken place under the ICC Act or Geneva Conventions Act. Legal framework places SA at the forefront of domestic prosecution of international crimes. Next page. 13.4.2.3 The direct application of customary international criminal law. Customary international law is automatically part of South African law unless inconsistent with the Constitution or an Act of Parliament. Section 232, Constitution 1996. Unlike treaty-based law, Section 231, Constitution 1996, customary international law does not require statutory incorporation. This allows direct prosecution of crimes under customary international law without reliance on the ICC Act or Geneva Conventions Act. Judicial recognition of direct application. S. V. Basson, Constitutional Court acknowledged the possibility but did not rule on whether customary international law alone could form the basis for prosecution. National Commissioner of Police v. Southern African Human Rights Litigation Center, SALC, CC. The court explicitly endorsed direct application under Section 232. Crimes such as torture, piracy, slave trading, war crimes, crimes against humanity, genocide, and apartheid are criminalized under customary international law. Torture is a crime in South Africa under both customary international law and domestic law. Torture Act. Crimes against humanity, including large-scale torture, are criminalized under Section 232, the Torture Act, and the ICC Act. Implications. Any customary international crime, including crime of aggression, could be prosecuted under this framework. However, Prosecutors must prove that the crime existed in customary international law at the time of the offense. Underscore 13.4.2.4 International Criminal Law in South African Courts. No core international crimes have been prosecuted under the ICC Act or Geneva Conventions Act. Courts have ruled on international criminal law principles and discussed universal jurisdiction cases. Key cases: 1. Bassan cases, SP Bassan I and II. 2. Sauk case, Zimbabwe torture docket. Underscore 13.4.2.4.1 The Bassan cases. Background: Wouter Bassan, Dr. Death, alleged involvement in mass murder, assassinations, and other acts possibly amounting to international crimes. Charged in 1999 with 67 counts, including 229 murders, conspiracy to murder, fraud, R36 million, drug-related offenses. Not charged with international crimes despite the serious nature of the allegations. Acquitted, April 2002, state unsuccessfully appealed. Key legal findings: SP Bassan I. International law obliges South Africa to prosecute crimes against humanity and war crimes. Apartheid constituted a crime against humanity, and some practices of the apartheid regime amounted to war crimes. SP Bassan II. National courts retain jurisdiction over international crimes despite the ICC's establishment. South Africa has an international obligation to prosecute war crimes and crimes against humanity. The court acknowledged grave breaches of the Geneva Conventions during apartheid. Contradiction with Azapo v. President of South Africa. Azapo held that the Geneva Conventions did not apply to South Africa's internal conflict. Bassan judgments contradict this by recognizing war crimes during apartheid. Significance: the Bassan trial exposed weaknesses in South Africa's domestic enforcement of international criminal law. Failure to rely on universal jurisdiction contributed to the prosecution's failure. Despite recognition of apartheid-era crimes, no further legal action followed. Underscore. These cases illustrate South Africa's legal commitment to international criminal law but highlight the lack of enforcement and prosecution in practice. Next. Page 13.4.2.4.2 The Sauk cases. Background: administrative review of the NPA and SAP's decision not to investigate a docket submitted by the Southern Africa Litigation Center, SALC, in March 2008. The docket alleged crimes against humanity committed in Zimbabwe in 2007. SALC requested an investigation under the ICC Act, marking the first South African court consideration of this act. Judgments: 1. High Court, May 2012. Found the state's failure to investigate unlawful and unconstitutional. Ordered SAPS to conduct an expeditious and comprehensive investigation and for the NPA to decide anew. 2. Supreme Court of Appeal, SCA, November 2013. Unanimously rejected SAPS and NPA appeal. Focused on Section 4.3 of the ICC Act, jurisdiction of SA courts over international crimes. SAP's argument that jurisdiction only applies when the perpetrator is present in South Africa was rejected. SCA found prescriptive jurisdiction applies regardless of location and perpetrator. SAPS has the competence to initiate investigations for crimes committed abroad. 3. Constitutional Court, October 2014. Upheld SCA decision, confirming that SAPS had not just the power but the duty to investigate international crimes. Key findings: jurisdiction in international law, confirmed legality of universal jurisdiction. Presence requirement, not required to commence investigations, though possibly needed for prosecution. Obligation to investigate international crimes, arises from the Constitution, ICC Act, and international law. Findings on universal jurisdiction. The Rome Statute preamble and treaty law impose a duty on states to exercise criminal jurisdiction over international crimes. Court expanded state obligations beyond territorial limits, emphasizing SA's responsibility to prevent impunity. Established 2 limitations on universal jurisdiction. 1. Subsidiarity and non-intervention. Crimes should be investigated only if the state with primary jurisdiction is unwilling or unable. 2. Practicability, consideration of likelihood of prosecution, proximity of SA to crime location, feasibility of obtaining evidence, resource constraints. Court did not cite legal authority for these limitations, suggesting they are policy-based principles. Application of principles to the case. SAP's argument on potential political effects of an investigation was rejected. Court emphasized SA's role in international justice and duty to hold perpetrators accountable. Confirmed SAPs must investigate the torture allegations, preventing SA from becoming a safe haven for criminals. Underscore 13.4.3 South Africa's future relationship with the ICC and international criminal justice. Complex relationship with international justice. Strong initial commitment, key role in drafting the Rome Statute. However, 1990s transition to democracy granted amnesty for some international crimes. Increasing alignment with African discontent towards the ICC. Tensions with the ICC. 2015, al-Bashir incident. SA refused to arrest President Omar al-Bashir, indicted for genocide, war crimes, and crimes against humanity. 2016, SA attempted withdrawal from the ICC, citing sovereignty concerns. 2017, reversed withdrawal decision after High Court ruled that executive action required parliamentary approval. Current position. SA remains a member of the ICC, but its enforcement of international criminal law is inconsistent. Despite contradictions, SA has developed a legal framework for prosecuting international crimes domestically. Next page. Chapter 14, International Trade Law, English Lemmer. Underscore 14.1 Introduction. International trade law has often been overlooked in general international law due to its close ties to economic law. WTO law is now recognized as a major component of international economic law, which in turn is part of international law. Trade is crucial for economic development but must be governed domestically and internationally to balance industry protection and consumer interests. International trade law refers to the legal framework governing trade, mainly through WTO agreements. Trade agreements between states/customs unions are typically in treaty form, incorporating international treaties, customary international law, general principles of law, international organization decisions, supranational law, for example, EU law, national laws affecting international economic relations. The WTO is the only international organization focused entirely on trade, ensuring liberalized trade through negotiations and dispute resolution. Established in 1995, the WTO has 164 members, covering 98% of world trade. The WTO does not regulate foreign direct investment, FDI, which is mainly governed by bilateral and regional investment agreements. Underscore 14.2 The nature of the World Trade Organization. WTO agreements are international contracts binding sovereign states and customs territories. Membership limits state sovereignty in trade matters. The WTO does not take independent decisions, it is member-driven, with decisions made by consensus. No decision has ever been taken without consensus among members. Underscore 14.3 The structure of the World Trade Organization. Functions: administer WTO agreements and serve as a negotiation forum. Key structures: Ministerial Conference, highest decision-making body, meets annually, appoints the Director General. General Counsel, acts on behalf of the Ministerial Conference, supervises various trade councils and the Dispute Settlement Body, DSB. Secretariat, handles the organization's administrative and operational work. The WTO is independent and does not function under the United Nations. Dispute Settlement Body, DSB, resolves trade disputes arising from WTO member obligations. Underscore 14.4 International law and international trade law. Conflict between economic liberalism and sovereignty. International trade law is based on comparative advantage and equal treatment. International law is based on state sovereignty and national interest. Sovereignty supports protectionism, which WTO rules prohibit. McRae, 2000, trade liberalization contradicts state sovereignty, as mercantilism, state-controlled trade, is opposite to a liberal trade order. Guzman, Powlin and Hillman. WTO rules sometimes override democracy to ensure rational trade policies. WTO agreements protect states from their own protectionist tendencies. Recent political trends show growing resistance to WTO authority, as nations seek to regain sovereignty over trade decisions. Similar concerns apply to the EU, where states have relinquished some sovereignty to supranational bodies, causing political backlash. Underscore. This covers the key points from the provided sections. Let me know if you need further details or additional sections. Next page. 14.5 Sources of international trade law. International trade law shares sources with international law, but WTO focuses on trade-specific norms. WTO dispute settlement system ensures compliance with trade rules through enforcement. Key sources of WTO law: treaties, customary international law, general principles of law, covered agreements and referenced international agreements. Dispute Settlement Body, DSB, plays a key role in treaty interpretation, especially where conflicts arise. _ 14.5.1 The legal force of dispute settlement reports. Legal authority of DSB reports is debated due to Article 9(2), WTO Agreement. Ministerial Conference and General Council have exclusive authority to interpret WTO agreements. Interpretation decisions require a 3/4 majority. DSB reports clarify WTO law but are only binding on the disputing parties. Japan, taxes on alcoholic beverages case, appellate body. Adopted panel reports create subsequent practice under Article 31(3) Vienna Convention on the Law of Treaties. However, adopted panel reports are not definitive interpretations. Ministerial Conference and General Council retain exclusive interpretative authority. Adopted reports create legitimate expectations but do not legally bind future cases. Unadopted reports lack legal status but may provide useful guidance. Appellate body rulings clarify existing law but cannot modify WTO agreements. Per Article 3.2 DSU. Note a jury precedent system and WTO dispute settlement. Panels should not disregard appellate body interpretations, as this undermines the WTO system. _ This summarizes the key points on the sources and legal authority of WTO dispute settlement reports. Let me know if you need further clarification. Next page. Study notes. The legal status of the WTO agreement in South African law and the purpose of the WTO _ 14.6 The legal status of the agreement establishing the WTO in South African law. A state is only bound by a treaty if it consents to it and it comes into force, pacta sunt servanda. Citizens can only rely on treaties if they are incorporated into domestic law. The General Agreement on Tariffs and Trade, GATT, 1947 was approved in South Africa via the Geneva General Agreement on Tariffs and Trade Act, 1948. However, Section 3 required a proclamation by the Governor-General for implementation. No proclamation was issued, so the agreement never became part of domestic law. This was confirmed in South Africa's 1993 Trade Policy Review, which stated that the GATT could not be invoked in South African courts. Some trade-related agreements were referenced in laws, for example, Customs and Excise Act, Section 74A, but these were not formally incorporated. Section 74A required interpretation in line with the Agreement on Implementation of Article 7 of the GATT 1979, Customs Valuation Agreement. However, mere reference to a treaty does not make it part of domestic law. The agreement establishing the WTO was signed by South Africa on April 15, 1994 and ratified on April 6, 1995. Parliament approved the agreement but did not pass an Incorporation Act, meaning it did not become domestic law. As per the Pan American Airways case, treaties require legislative enactment to be part of domestic law. The Supreme Court of Appeal in Progress Office Machines v. SARS reaffirmed that WTO agreements do not confer rights on South African citizens. Since GATT 1994 replaced GATT 1947, the 1948 Act remains on the statute books but is legally obsolete. _ 14.7 The purpose of the World Trade Organization. The WTO balances political pressures for trade restrictions with economic theories supporting trade liberalization. It manages multilateral trade rules and provides a forum for trade negotiations and dispute resolution. Established in 1995, following the Uruguay Round, 1986 to 1994. The Doha Development Agenda, 2001, is the current negotiation round. The WTO aims to liberalize trade by reducing tariff and non-tariff barriers. Ensure trade barriers protecting consumers, the environment, and health are justified and regulated. Facilitate trade by providing a transparent, predictable, and legally certain system. The WTO dispute settlement system is the exclusive forum for resolving WTO-related trade disputes. Boyson's view. GATT is an interstate agreement creating binding international law. Other WTO agreements involve individual traders, complicating the legal framework. Next page. Here's a structured and detailed summary of the provided text in bullet point format. _ 14.8 Basic principles underpinning the World Trade Organization system. WTO law is a complex set of rules governing trade in goods, services, and intellectual property. 5 main groups of WTO rules. 1. Non-discrimination rules. 2. Market access rules. 3. Rules on unfair trade. 4. Rules on the conflict between trade liberalization and societal interests. 5. Institutional and procedural rules, for example, WTO decision-making, trade policy review, dispute settlement. 14.8.1 Non-discrimination. 14.8.1.1 Most Favored Nation, MFN, Principle. Core principle of international trade ensuring non-discrimination among WTO members. Contained in GATT Article I, Trade in Goods, SPS Agreement Article 2.3. TBT Agreement Article 2.1. GATT's Article 2, Trade in Services, TRIPS Article 4, Intellectual Property, prohibits discrimination between trading partners. WTO members must offer the same treatment to all countries. No preferential treatment for specific countries unless permitted by exceptions. GATT Article 24 allows preferential trade agreements. Enabling clause permits developed countries to grant tariff preferences to developing countries. GATT's exceptions. Economic integration agreements. Labor market integration agreements. Special and differential treatment, SDT, provisions. Provide flexibility for developing countries. Effectiveness debated. 14.8.1.2 National Treatment Obligation. Prevents discrimination against imported products in favor of domestic products. Contained in GATT Article 3, Goods, GATT's Article 17, Services, TRIPS Article 3, Intellectual Property. 2 Aspects of non-discrimination. 1. Between like products of different origins, for example, imported versus domestic goods. 2. After goods enter the market, internal taxation and regulation. Key distinction between goods and services. Goods, national treatment applies to all trade measures. Services, applies only to specific service sectors listed in a country's schedule of specific commitments. Key case law. Canada, periodicals, WTO appellate body, 2-part test for GATT Article 3:2 violations. 1. Are the imported and domestic products like products? 2. Are the imported products taxed in excess of domestic products? Japan, customs duties, taxes and labeling practices on imported wines and alcoholic beverages, 1987 panel report. Japan imposed higher taxes on imported vodka than on domestic shochu. Panel found that vodka and shochu were like products based on their properties, uses, and tariff classification. Higher taxation of imported vodka violated GATT obligations. 14.8.2 Market access. States protect local producers using tariffs on imports. Tariffs increase the price of imports, reduce competition, potentially lowering efficiency and raising consumer prices. Tariffs are the only WTO-permitted protection measure. Market access rules ensure predictability and security in international trade. 14.8.2.1 Market access, trade in goods. Trade barriers. Tariff barriers, taxes on imports. Non-tariff barriers, quantitative restrictions, for example, quotas, regulatory barriers, etc. GATT/WTO principles. Objective, gradual tariff reduction. Members commit to tariff ceilings. GATT Article 2, Tariff bindings. Members can set maximum tariff rates for specific products. Once set, they become binding obligations under GATT Article 2:1. Some WTO members, for example, EU, US, have bound tariffs for all products, others have bound only a few. 14.8.2.2 Market access, trade and services. GATT's framework differs from GATT. Services trade is intangible, for example, legal, transport, financial, IT, education. Growing importance. Africa's services exports grew 14% in 2017. South Africa's service exports grew 9.8% per annum, holding 0.29% of world trade. 2 types of GATT's obligations. 1. General obligations, apply to all WTO members. Most favored nation, MFN, treatment. Transparency rules, mandatory disclosure of regulations. 2. Specific commitments, market access and national treatment commitments made by individual members. Found in each country's schedule of specific commitments. May include restrictions and conditions. 14.8.2.2.1 Application of GATS. Scope. Covers all services except those supplied in the exercise of governmental authority, for example, public healthcare. Air transport excluded. Annex on air transport services. GATS applies to all government measures affecting services trade. Definition of trade and services. Article I.2. 4 modes of supply. 1. Cross-border supply, service supplied from one country to another. 2. Consumption abroad, consumers travel to another country to receive a service. 3. Commercial presence, foreign companies establishing a presence in another country. 4. Presence of natural persons, temporary movement of professionals to supply services. Market access and national treatment depend on a country's schedule of specific commitments. Commercial presence, Mode 3. Allows foreign investment by setting up businesses in another country. Presence of natural persons, Mode 4. Does not cover permanent migration, citizenship, or long-term employment. Underscore. This summary maintains depth and detail while structuring the content clearly. Let me know if you need modifications. Next. Page 14.9 Trade Remedies. WTO permits anti-dumping duties and countervailing duties under specific conditions set by WTO agreements. Purpose: protect domestic producers and traders from unfair trade practices, dumping and subsidies. Complaints originate from individual traders or industries submitted to the government/customs body. WTO members may deviate from obligations if conditions are met, for example, to protect a national economy or industry. Primary trade remedies in WTO agreements. 1. Safeguards, temporary relief from sudden import surges that harm local industries. 2. Anti-dumping duties, offset unreasonably low import prices that harm domestic industries. 3. Countervailing duties, counteract subsidies that distort fair trade. Underscore. 14.9.1 Safeguards. Definition: temporary measures limiting imports of specific goods affecting all exporters. Conditions for implementation. A sudden surge in imports causes serious prejudice to domestic industry. No unfair/bad practice involved. Contrast with anti-dumping/countervailing duties. United States, definitive safeguard measures on imports of circular welded carbon quality line pipe from Korea. Appellate body. Safeguards are import restrictions without an unfair trade practice allegation. Legal basis. GATT Article 19(1)(a), Escape Clause, allows deviation from WTO obligations to prevent or remedy serious injury. Agreement on Safeguards elaborates on Article 19 and ensures compliance. Sector-specific provisions. Agriculture, Agreement on Agriculture, Services, GATS. 14.9.1.1 Article 19 GATT, Escape Clause, allows safeguard measures if unforeseen developments lead to increased imports. These imports cause serious injury to domestic producers. Measures are temporary and limited to remedy the injury. 14.9.1.2 The Agreement on Safeguards clarifies and strengthens Article 19 GATT 1947. United States, Line Pipe Safeguard. Appellate body highlighted tension between using safeguards and maintaining trade concessions. Article 2. Safeguards apply only when imports increase significantly, causing/threatening serious injury to domestic industries. Article 3(1), before imposing safeguards, an investigation is required, ensuring transparency. Article 4(1)(a), defines serious injury as a significant overall impairment of domestic industry. United States, safeguard measures on imports of fresh, chilled or frozen lamb meat from New Zealand and Australia. Standard for serious injury is stricter than material injury, used for anti-dumping/countervailing duties. Causality, safeguards must be proportional to the injury caused. Underscore. 14.9.2 Anti-dumping. Definition: selling goods below normal value in an import market. Dumping is not an act of a foreign government, but an exporter's action. WTO allows anti-dumping duties if 1. An investigation confirms dumping. 2. A dumping margin is determined. 14.9.2.1 Article by GATT. Dumping is condemned if it causes/threatens material injury or retards a domestic industry. 3 conditions for a dumping determination. 1. Selling below normal value. 2. Material injury to domestic industry. 3. Retarding domestic industry development. Anti-dumping agreement, ADA. Article 2. Dumping occurs when a product's export price is lower than its domestic market price. If dumping margin is de minimis, the case is dismissed. Normal value determination. If no domestic market exists, constructive normal value is used. Material injury standard is lower than the serious injury standard for safeguards. If causal link proven, anti-dumping duties apply for max 5 years. Preliminary duties can be imposed before investigation completion. _ 14.9.3 Countervailing duties. Definition: imposed to counteract subsidized exports. Subsidy equals government benefits improving a producer/exporter's competitiveness. Types of subsidies: tax rebates, credits, loan guarantees, grants, equity infusions. WTO considers subsidies unfair trade practices. Legal framework. GATT Articles V, 16 and 13. Agreement on Subsidies and Countervailing Measures, ASCM. Requirements: 1. Prove subsidy exists. 2. Prove it causes serious injury to domestic industry. 3. Establish a causal link between subsidy and injury. Countervailing duties imposition. Can be imposed as long as the subsidy continues. Can be enforced domestically or through WTO dispute settlement body. _ 14.10 Preferential trade areas. Definition: WTO members can form preferential trade areas, PTAs, with lower tariffs among members. Exception to MFN obligation, GATT. 2 types. 1. Free trade areas. 2. Customs unions. Example: Southern African Customs Union, SACU, Est. 1910. The oldest customs union. South Africa is a member of various PTAs and free trade areas. PTAs impose additional international law obligations. _ These notes provide a structured and in-depth summary of the trade remedies and preferential trade areas covered in the provided text. Let me know if you need any modifications or further breakdowns. Next page. Here's a condensed version of the provided text in bullet point format, maintaining key details, legislation, and case law references. _ 15. Legal Protection of the Environment, Werner Schultz. 15.1 Introduction. Focus: International Environmental Law, Laws Addressing Global Environmental Protection. Divided into 3 parts. 1. Historical Development of International Environmental Law. 2. Sustainable Development and Environmental Law Principles. 3. Key Challenges in African Union's Environmental Regulations. _ 15.2 Key Developments in International Environmental Law. Modern international environmental law emerged in the 1960s, though treaties date back to the 19th century. Early treaties were bilateral agreements on fisheries, watercourses, and wildlife protection. Soft law has played a significant role in legal development. _ 15.2.1 Stockholm and the First Set of Common Principles. Trail Smelter Case, 1941, Canada, USA. Key principle: no state has the right to use its territory in a way that harms another state's environment. Confirmed by the ICJ in the Corfu Channel case, UK v Albania, regarding state responsibility. Laclanu Arbitration, 1963, Spain, France. Upper riparian states must avoid causing serious harm to lower riparian states when altering watercourses. UN Conference on the Human Environment, Stockholm, 1972. First major international environmental conference. Produced Stockholm Declaration, 26 non-binding principles plus 109 recommendations. Key Stockholm Declaration principles. Principle 1. Human right to a healthy environment, responsibility to protect it for future generations. Principle 8. Economic and social development crucial for improving environmental conditions. Principle 9. Financial and technological aid required for developing countries to rectify environmental deficiencies. Principles 10 to 12. Acknowledge North-South divide in development needs. Principle 11. Environmental policies must not adversely affect developing countries' economic growth. Principle 21. States have sovereign rights over resources but must prevent transboundary environmental harm. Confirmed by ICJ in the nuclear weapons case. Principle 21. Extension covers common heritage of mankind areas beyond national jurisdiction. United Nations Environment Programme, UNEP, created in 1972 to monitor and develop environmental policies globally. _ This summary preserves the key legal principles, case law, and institutional developments. Let me know if you need further refinements. Next. Page. Next. Page. Here's a condensed version of your text with all key points. Underscore. 15.2.2 Rio and the Interdependence of Development and the Environment. Global Initiatives Post-Stockholm Declaration. 1980 World Conservation Strategy, IUCN, WWF, UNEP, influenced policies and legal frameworks on sustainable development, revisited as Caring for the Earth Strategy, 1991. 1982 World Charter for Nature, non-binding, focuses on nature protection as an intrinsic goal. 1987 Brundtland Report, expanded sustainable development's role, linking it to peace, security, and development. 1992 United Nations Conference on Environment and Development, Rio Conference. Produced 3 non-binding instruments. 1. Rio Declaration on Environment and Development, 27 Principles emphasizing sustainable development. 2. Statement of Forest Principles, weak, vague provisions on forest management. 3. Agenda 21, Political Action Plan for implementing the Rio Declaration, facilitated the signing of 2 multilateral environmental agreements, MAEAs. United Nations Framework Convention on Climate Change, UNFCCC. Convention on Biological Diversity. North-South Divide on Environmental Responsibilities. Developing states argued pollution resulted from industrialized nations, therefore, corrective measures should be their responsibility. Rooted in post-colonial economic self-determination movements, 1950s-70s, demanding trade reform, debt relief, technology transfer, and better market access. Key themes in Agenda 21. Sustainable development as a global priority. Recognition of economic inequalities, calls for financial assistance and an equitable global economy. Core principles of the Rio Declaration. Integration, Principle 4. Sustainable development must integrate environmental and economic policies. Public participation, Principle 10. Environmental decisions require inclusive governance. Precautionary approach, Principle 15. Uncertainty should not delay protective measures. Right to development, Principle 3. Development is a fundamental right. Common but differentiated responsibilities. CBDR, Principle 7. Developed countries bear greater responsibility. Polluter pays, Principle 16. Those causing pollution should cover costs of damage. 2002 World Summit on Sustainable Development, WSSD, Johannesburg. Reaffirmed Rio Principles. Introduced public-private partnerships, PPPs, for sustainable development. Established a partnership database, 2004, administered by the Commission on Sustainable Development, CSD. Underscore. 15.2.3 Post-Rio Developments. 2000 United Nations Millennium Declaration. Reaffirmed sustainable development, emphasizing economic development and poverty eradication. Environmental protection. Special attention to Africa. 2002 WSSD 10-year review. Confirmed Rio principles but failed to introduce new policies. Criticism, need for action, not reiteration. 2012 Rio Plus 20, 20-year review. Strengthen UNEP's role in interagency cooperation. Replace CSD with High-Level Political Forum on Sustainable Development, HLPF, under ECOSOC and General Assembly, focused on green economy but stalled due to financial demands by developing states. Criticism, lack binding targets and deadlines. Victory for developing nations, recognized poverty eradication as the primary sustainable development challenge. Launched Process for Sustainable Development Goals, SDGs. 2015 UN General Assembly Resolution 71, Agenda 2030. 17 SDGs, 169 targets, covering economic, social, and environmental issues. No separate environmental goal, but SDG 6, 13, 14, 15 form an environmental cluster addressing water management, climate change, biodiversity conservation, marine resource protection, potential to shape international environmental law, for example, promoting ecosystem approach in international freshwater law. 2018 UN General Assembly Resolution 72-277, towards a global pact for the environment. Called for a report on gaps in international environmental law. Proposal, a unifying instrument consolidating environmental principles. Concerns, risk of duplicating existing laws without meaningful change. Lack of state support for implementation. Underscore. This summary condenses the original text while retaining key legislative and legal principles. Let me know if you need any refinements. Next page. Here's a condensed and structured summary of the provided text. Underscore. 15.3 Actors in International Environmental Law. Shift in Global Environmental Governance. Bierman, Shift from State-Centered Governance to a Multi-Actor System. States, international organizations, NGOs, scientists, activist groups, business associations. States remain primary actors, but their role has evolved due to legal changes. Role of NGOs in international environmental law. Proliferation of NGOs influencing treaty negotiations, enforcement, and monitoring. Recognized in Rio Conference, 1992, Agenda 21, Section 3. Many MAs grant NGOs observer status, for example, Article 7.6 UNFCCC, Article 15.6 Basel Convention. NGOs act as agenda setters, identifying key issues, conscience keepers, mobilizing pressure for action, scientific and technical advisors to treaty bodies. States versus non-state actors. States remain key actors in treaty making and customary international law. Legal personality discourse. Dream data, mankind as an emerging legal subject, referencing UNFCCC and CBD preambles. Future generations lack recognized legal rights in international law, international organizations and environmental law. No UN specialized agency has primary environmental responsibility. Key contributors, FAO, WHO, IMO, with UNEP as the main environmental body. Proposals for a global environmental organization, GEO. Upgrading UNEP to a specialized agency. Creating an entity like the WTO for the environment. Establishing a supranational enforcement body. High-level political forum on sustainable development, HLPF. Replace the Commission on Sustainable Development, CSD. Provides leadership, reviews sustainability progress, and integrates development dimensions. Multilateral environmental agreements, MAEAs, and governance structures. MAEAs create dynamic international regimes to address environmental challenges. Key mechanisms. Conference of the Parties, COPs. Permanent regulatory bodies overseeing treaty implementation. Meet regularly, for example, UNFCCC COP meetings can amend treaties, protocols, and annexes. COP decisions generally non-binding unless treaty amendment is ratified, for example, Article 18 Kyoto Protocol. Secretariats. Administer treaty implementation, often under UNEP. Provide technical assistance, draft COP decisions, monitor compliance. Subsidiary bodies. Focus on scientific advice, technology transfer, financial assistance. Underscore. 15.4 Sustainable Development and International Environmental Law. Definition and Legal Status. Brundtland Report, 1987. Development that meets the needs of the present without compromising future generations. Unclear legal status, not a strict legal obligation but influences treaty interpretation, state practice, and court decisions. Conflicting interpretations. Right to development, sovereignty, versus environmental protection. Rio Declaration Principle 3, balances development and environmental needs of present and future generations. Sands and Peel's 4 elements of sustainable development. 1. Intergenerational equity. 2. Intragenerational equity. 3. Sustainable use. 4. Integration principle. 15.4.1 Intergenerational equity. Edith Brown Weiss theory. Each generation must 1. Pass the planet in no worse condition. 2. Ensure equitable access to resources. 3. Repair past environmental damage. Supported by international instruments and case law, for example, nuclear test case, Judge Weirmantree. Legal challenges. No recognized justiciable rights for future generations in international law. No legal representation of future generations in international courts. National courts, for example, Philippines timber case, may grant standing for future generations. Conceptual issues. Unclear implementation. Why should current generations sacrifice for unknown future needs? Subjectivity. Present generations make assumptions about future interests. 15.4.2 Intragenerational equity. Focus on equity among present generations. North-South divide, inequalities in resources and environmental impact. Urgent need to bridge wealth gaps to ensure a fair world for future generations. Differential treatment in MAEAs, for example, CBDR principle, ensures fairness. Underscore. This summary retains key concepts while eliminating unnecessary explanations. Let me know if you need adjustments. Next page. Study notes on Sustainable Development Principles. 15.4.3 The Principle of Integration. Rio Declaration Principle 4. Environmental protection must be integrated into economic development, recognized as a general principle of international law. Iron Rhine Case. UNFCCC Preamble. Climate responses should align with economic and social development. Impact on other legal areas. Environmental considerations increasingly influence international trade. Different areas of international law are becoming interconnected. 15.4.4 Sustainable Use. Defined in Article 2, Convention on Biological Diversity, CBD. Use at a rate that does not cause long-term biodiversity decline, reflected in Article 2, UNFCCC. Ensures ecosystems adapt to climate change without compromising food production or economic growth. Related concepts. Conservation. Sustainable management. Maximum sustainable yield. Optimum sustainable productivity. Customary international law status. Unclear if sustainable use is a binding norm. Exists in specific areas like high seas, deep seabed, Antarctica, and the Moon. Criticism of sustainable development. Initially useful for broad consensus, now criticized for lacking clarity in balancing environmental, economic, and social trade-offs. Economic growth often prioritized over environmental concerns. 15.5 Principles underlying sustainable development. Principles in international environmental law. Guide rule negotiation and application. Have legal consequences but do not dictate specific actions. Require balancing conflicting principles. Dworkin's distinction from rules. 15.5.1 Common but differentiated responsibilities. CBDR. Rio Declaration Principle 7. States share responsibility for environmental protection but not equally. Developed countries bear greater responsibility due to past contributions to degradation and greater resources. CBDR in environmental treaties. Article 3.1 UNFCCC recognizes CBDR and respective capabilities. CBDRRC. Core elements. Common responsibility. All states must protect the environment. Differentiation. States have different obligations based on historical contributions to degradation, capacity to address the issue, differential treatment in treaties, emission targets, varied obligations, implementation, for example, delayed compliance for developing nations, assistance provisions, financial and technological aid, evolving debate. Emerging economies, for example, China, contribute significantly to emissions. Growing call for differentiation within developing countries. Disagreement on whether CBDR is based on historic responsibility. Developed states should pay for past emissions. Respective capabilities, current economic ability to act. Customary law status. Unclear if CBDR is customary international law. Majority view, not yet a binding norm. 15.5.2 Precautionary Principle. Rio Declaration Principle 15. Environmental protection requires precautionary measures. Scientific uncertainty should not delay cost-effective measures to prevent degradation. Adoption in treaties and case law. Included in multilateral environmental agreements, MAEAs, referred to by international courts. Unclear customary law status. Lacks a concrete definition and clear obligations. Debate over meaning of full scientific certainty. The scope of necessary actions could become a binding rule through treaty law over time. Next page. Study notes, Principles of Sustainable Development in International Environmental Law. 15.4.3 The Principle of Integration. Principle 4 of the Rio Declaration, environmental protection must be integrated into development and cannot be considered in isolation. Iron Rhine Arbitration. Integration of environmental measures into economic activities is a requirement of international law. Contemporary understanding, integration encompasses social, economic, and environmental considerations. Examples in international law. UNFCCC Preamble. Climate change responses must be integrated with socio-economic development. International trade law. Environmental considerations increasingly affect trade regulations. 15.4.4 Sustainable Use. Convention on Biological Diversity, Article 2, Sustainable use must prevent long-term biodiversity decline. UNFCCC, Article 2, Climate policies should allow ecosystems to adapt, protect food security, and support sustainable economic development. Related concepts: conservation, sustainable management, maximum sustainable yield, and optimum sustainable productivity. Legal status: not yet considered customary international law. General obligations exist regarding sustainable use in high seas, deep seabed, Antarctica, and the Moon. Criticism: sustainable development lacks specificity, making it ineffective for decision-making. 15.5 Principles underlying sustainable development. Nature of principles in international law differ from rules as they must be balanced rather than strictly applied. Guide states in lawmaking and treaty interpretation. Carry normative weight without prescribing specific behavior. 15.5.1 Common but differentiated responsibilities, CBDR, Principle 7 of the Rio Declaration. All states share responsibility for environmental protection. Developed states bear greater responsibility due to past environmental degradation and financial/technological capabilities. Examples in international law: UNFCCC, Article 3.1, CBDR and respective capabilities, CBDRRC, recognized in climate governance. Objectives of CBDR: 1. Promote substantive equality. 2. Facilitate international cooperation. 3. Incentivize compliance through assistance. Forms of differential treatment. Different emission targets. Extended compliance timelines. Financial and technological support. Challenges. Disagreement over whether CBDR is based on historical responsibility or economic capabilities. Not yet recognized as customary international law. 15.5.2 Precautionary Principle. Principle 15 of the Rio Declaration. Scientific uncertainty should not delay cost-effective environmental action. Application in international law. Incorporated in multiple multilateral environmental agreements, MAEAs. Cited in international court rulings. Legal status. Debate over whether it has attained customary law status. Core principle: lack of full scientific certainty cannot justify inaction. Challenges. Defining full scientific certainty and appropriate response measures. Unclear legal obligations for states. 15.5.3 Principle of Prevention and Permanent Sovereignty over Natural Resources. Principle 2 of the Rio Declaration. States have sovereign rights over their resources but must prevent environmental harm beyond their jurisdiction. Permanent sovereignty. Originated to protect developing states' economic independence. Affirmed in UNGA Resolution 1803, 1962. And UNFCCC Preamble, now includes obligations towards sustainable resource use. Principle of Prevention. States must prevent transboundary environmental harm. ICJ, Pulp Mills case, prevention is a customary international law obligation. Environmental Impact Assessments, EIAs. Principle 17 of the Rio Declaration, EIAs are required for significant environmental risks. ICJ, Pulp Mills case, EIAs are a general international law requirement for transboundary harm. 15.5.4 Polluter Pays Principle. Principle 16 of the Rio Declaration. Polluter should bear the costs of pollution through economic instruments. Application. Primarily applies at the domestic level. Implemented via taxes, levies, subsidies, and liability laws. Challenges. No clear international legal obligation. Potential conflicts with trade and investment policies. These notes provide a structured summary of key principles governing sustainable development in international environmental law. Next page. Study notes, key issues in international environmental law. 15.6 Key issues in international environmental law. Environmental law is broad and complex. The following are selected pressing issues. Discussion includes relevant legal instruments but does not imply exclusion of other significant issues. Underscore. 15.6.1 Freshwater resources. Global water crisis. 663 million people lack access to improved drinking water. 2.4 billion people lack access to improved sanitation. Causes: environmental degradation, overexploitation. Traditional focus of international water law. Historically concerned with water allocation rather than environmental protection. Shift towards sustainability and ecological considerations in recent developments. Theories of water use in international law. 1. Absolute territorial sovereignty. States can use water freely within their borders, ignoring downstream effects. 2. Absolute territorial integrity. Downstream states have the right to receive natural water flow without interference. 3. Limited territorial integrity. States can use water freely as long as they do not harm co-recipients states. 4. Equitable use. Most widely accepted, states must use shared water resources in an equitable and reasonable manner. Legal frameworks governing freshwater resources. UN Watercourses Convention, 1997. Article 5. States must use international watercourses in an equitable and reasonable manner. Article 6. Lists non-exhaustive factors for determining equitable use. Article 7. Obligation not to cause significant harm. Article 10(2). In case of conflict, human needs, drinking, sanitation, nutrition, take priority. South Africa signed the convention in 1997. Regional agreements in Africa. Zambezi River Agreement, 1987, addresses environmental management of the Zambezi River. SADC Protocol on Shared Watercourses, 2003. Encourages shared watercourse agreements and institutions. Promotes sustainable, equitable, and reasonable water use. Harmonizes legislation and policies for shared water management. Nice Convention on the Protection and Use of Transboundary Watercourses, 1992. Initially regional, amendments allow global accession. More detailed than the UN Watercourses Convention. Article 2. States must prevent, control, and reduce transboundary water pollution. Article 2.5. Incorporates precautionary principle, polluter pays principle, and intergenerational equity. Article 3. Requires legal, administrative, and economic measures to address transboundary pollution. ILC Draft Articles on the Law of Transboundary Aquifers, 2008. Addresses groundwater resource management. Article 3. Recognizes sovereignty over aquifers within national borders. Article 4. Affirms equitable and reasonable utilization. Article 6. Obligation not to cause significant harm. Article 7. Duty to cooperate. Article 10. Protects ecosystems. Article 12. Introduces pollution control and precautionary approach. Potential to develop into a binding international treaty. Underscore. These notes summarize key legal instruments and principles governing freshwater resource management in international environmental law. Next. Page 15.6.2 Ozone depletion and climate change. Vienna Convention and Montreal Protocol. Vienna Convention for the Protection of the Ozone Layer, 1985. Initiated by UNEP in response to scientific evidence of ozone depletion. South Africa ratified in 1995. Framework Convention with broad, vague language. Does not impose specific obligations, requires further action via protocols. Montreal Protocol on Substances that Deplete the Ozone Layer, 1987. Article 2. Complex scheme of control measures for ozone-depleting substances. Article 4. Trade bans between certain country groups. Article 5. Differential treatment for developing countries, 10-year compliance delay for those with less than 0.3 kilograms per capita consumption of Annex A substances. Article 10. Establishes a multilateral fund for technical assistance and technology transfer. Article 8. Introduces a soft non-compliance procedure through an implementation committee. South Africa adopted the protocol in 1990. Expected to restore ozone layer to pre-1980 levels by 2050 to 2075. Climate Change and International Law. IPCC 2007 report, Human-Induced Greenhouse Gas, GHG, emissions are the primary cause of climate change. Fifth Assessment Report, confirms that recent anthropogenic emissions are the highest in history. Climate change affects water, food, health, land use, and the environment. Global issue, effects not dependent on emission location, poorest states are most vulnerable. UNFCCC, 1992. Objective, stabilize GHG concentrations to prevent dangerous anthropogenic interference. Guiding principles. Common but differentiated responsibilities and respective capabilities, CBDRRC. Special circumstances/vulnerabilities principle. Precautionary approach. Sustainable development. Mutual support/coherence between international and climate regimes. Article 4. Developed countries, NXI, must adopt mitigation policies. Developing countries required to establish GHG inventories. Article 4.3. Developed countries, Annex 2, must provide financial resources to assist developing countries. Institutional structure includes COP, Secretariat, subsidiary bodies, and financial mechanisms. Kyoto Protocol, 1997, negotiated under the Berlin Mandate at 1 Colombian peso, entered into force February 16, 2005 after Russia's ratification, sets quantitative emission reduction targets for industrialized states. Annex I. Article 3.1 requires 5% reduction below 1990 levels, 2008 to 2012 commitment period. Introduces 3 flexibility mechanisms for emission reductions. Article 3.3 and 4 allows land use change in forestry activities to count toward reduction targets. COP supervises implementation with scientific advice from SBSTA and SBI. Compliance mechanisms include multilateral consultative process, dispute avoidance. Article 14 and 19, peaceful dispute resolution, negotiation, conciliation, judicial settlement. Article 18, non-compliance procedure under the Marrakesh Accords. Post-Kyoto developments. COP 13/MOP3, Bali, 2007. Bali Roadmap, 2-track process, AWGKP for Kyoto commitments and AWGLCA for long-term cooperation. 15 Colombian pesos, Copenhagen, 2009. Failed to deliver a binding post-2012 regime. Resulted in the Copenhagen Accord, requiring both Annex I and non-Annex I countries to submit emission reduction pledges. Cancun Agreements, 2010. Recognized Copenhagen Accords mitigation targets. Durban Platform, 2011. Launched negotiations for a legally binding post-2020 agreement. Doha Conference, 2012, established the Warsaw International Mechanism for Loss and Damage. Paris Agreement, 2016, legally binding global agreement with non-binding provisions. Objective, limit global temperature rise to well below 2 degrees Celsius, with efforts toward 1.5 degrees Celsius. Article 4. Establishes global emissions peaking goal. Introduces nationally determined contributions, NDCs. NDCs to be revised every 5 years, with increasing ambition. Article 419. Encourages long-term low-emission strategies. Article 6. Article 6.2. Introduces international emissions trading. Article 6.4. Establishes a market-based mitigation mechanism. Article 7. Recognizes adaptation as a global challenge. Article 7.9 requires adaptation planning but allows flexibility, as appropriate. Article 8 recognizes loss and damage but does not establish liability/compensation. Article 9. Developed countries must provide financial support. No new quantitative financial commitments imposed. Article 13, transparency framework to ensure accountability in mitigation, adaptation, financial contributions. Article 14, establishes a stocktake mechanism every 5 years, beginning in 2023. Article 18, introduces a non-adversarial, non-punitive compliance mechanism. Implementation and rule development. Ad hoc Working Group on the Paris Agreement, APA, oversees rule development. 22 Colombian pesos and 23 Colombian pesos, focused on Paris Agreement Rulebook. 24 Colombian pesos, 2018, adopted the rulebook, finalizing implementation guidelines. Next page. 15.6.3 Waste and hazardous substances. Increase in waste and hazardous substances has negatively impacted the environment. Transboundary movement of waste, particularly illegal exports from developed to developing countries, has led to international regulations. Basel Convention, 1989, regulates transboundary movement and disposal of hazardous waste in an environmentally sound manner. Key provisions. Article 4.2, obligations on waste generation and adequate disposal. Article 4.3, states consider illegal waste trafficking as criminal. Article 4.5, prohibits exports to and imports from non-parties. Article 8, duty of re-import if movement cannot be completed per contract. Article 12, led to Basel Protocol on Liability and Compensation, 1999, for damages caused by hazardous waste spills. Basel ban and legal disputes. 2 Colombian pesos, Decision 2/2, prohibited hazardous waste movement for disposal from OECD to non-OECD states, phased out movements for recycling by 1993. 3 Colombian pesos, Basel ban amendment added. Legal dispute. Article 17.5 interpretation led to disagreement on whether the amendment entered into force. 10 Colombian pesos, Decision BC 10/3, addressed Basel ban's entry into force. Bamako Convention, 1991, response to cocoa incident. Prohibits hazardous waste imports into Africa from non-African Union countries but allows certain transboundary movements between African states. Regulation of hazardous chemicals and pesticides. Rotterdam Convention, 1988, regulates trade in hazardous chemicals and pesticides. Covers, banned or severely restricted chemicals and severely hazardous pesticide formulations. Articles 10 and 11, establish prior informed consent procedure, Annex 3. Stockholm Convention, 2001, targets persistent organic pollutants, POPs. Article 3(1)(a), requires elimination of chemicals in Annex A. Annex B chemicals, subject to restrictions. Article 3(3), prevents production of new POPs. Includes, regulations on stockpile management and emission reduction. Underscore. 15.6.4 Biological diversity. Human activities causing rapid biodiversity loss. Convention on Biological Diversity, CBD, 1992, is the main international treaty. CBD key provisions. Definition, Article 2, biodiversity includes variability among living organisms and ecosystems. Preamble, recognizes intrinsic value of biodiversity and states sovereign rights over natural resources. Objectives. 1. Conservation of biological diversity. 2. Sustainable use of biodiversity components. 3. Fair and equitable benefit sharing of genetic resource utilization. Article 10. Obligations for sustainable use of biological resources. Articles 16 to 19, regulate technology transfer. Article 16.2, transfer subject to intellectual property rights. Article 16.4, private sector must facilitate access and joint development of technology. Access and benefit sharing of genetic resources. Article 15, access based on mutually agreed terms and prior informed consent. Article 16, technology transfer on fair terms. Bond Guidelines, 2002, 6 Colombian pesos, provide non-binding guidance on access and benefit sharing. Nagoya Protocol, 2010, 10 Colombian pesos, legally binding agreement expanding access and benefit sharing regime. Cartagena Protocol on Biosafety, 2000, scope, covers transboundary movement, handling and use of living modified organisms. Precautionary approach, reflected in multiple provisions. Key provisions. Advance Information Agreement Procedure, ensures informed decision-making before import. Biosafety Clearinghouse, facilitates information exchange and protocol implementation. Next page. Study Notes, State Responsibility and Liability, 15.6.5 Distinction between state responsibility and liability. State responsibility, related to internationally wrongful acts, discussed in Chapter 4. State liability, often refers to environmental damage from lawful activities, including civil liability of non-state actors. International responsibility arises when a breach of an international obligation leads to environmental damage. Rarely used in international environmental law due to a preference for cooperation over confrontation. Difficult to apply in cases like climate change, where multiple states contribute to harm. MAEAs, multilateral environmental agreements, prefer treaty-based enforcement and compliance through cooperation and negotiation. Liability and compensation for environmental harm. Recognized in early international law. Principle 22 of the 1972 Stockholm Declaration, calls for cooperation to develop international liability and compensation law. Principle 13 of the 1992 Rio Declaration, urges states to enforce this duty expeditiously. International Law Commission, ILC, contributions. 2001 Draft Articles on Prevention of Transboundary Harm from Hazardous Activities. Focus on prevention, rather than liability. Prevention equals a duty or procedure applied before harm occurs. Justified because compensation cannot fully restore damage. Scientific knowledge of hazards increases over time. Causal links between harm and activities are easier to establish. Due diligence obligation, not obligation of result, but of conduct. States must demonstrate best efforts in preventing transboundary harm. Standard varies based on state capacity, developed versus developing states. State responsibility versus international liability. Draft Articles, Article 1. Apply only to activities not prohibited by international law that pose a risk of significant transboundary harm. Distinction. State responsibility applies when failure to prevent harm results in a wrongful act. International liability can arise even if no legal obligation was breached, for example, health issues from water contamination. Types of environmental liability. Private operator, primarily responsible for remedying environmental harm. Forms of liability. Joint and several liability. Multiple entities can be individually pursued for full compensation. Fault-based liability. Liability based on recklessness, negligence, or wrongful conduct. Strict liability, based solely on risk, regardless of fault or negligence. State responsibility, applies if a private operator cannot financially compensate victims. Examples of liability in international law. 1989 Basel Convention, on hazardous waste. Exporting state must notify affected states before transboundary waste movement. Article 6. 1999 Basel Protocol, on liability and compensation. Notifying entity strictly liable until waste reaches final disposer. Joint and several liability applies when multiple actors are involved. Article 4.6. Financial guarantees. Article 14. Requires insurance/bonds to cover liability. 2000 Cartagena Protocol on Biosafety, under Biodiversity Convention. Article 27. Mandates the development of liability and redress rules for LMOs, living modified organisms. 2010 Nagoya Kuala Lumpur Supplementary Protocol. Article 12. Allows states to develop national liability laws for LMOs. Article 11. Ensure state responsibility rules remain unaffected. Developing countries sought a strong international liability regime, but LMO exporting nations resisted. Threshold for liability, significant transboundary harm. Defined in draft articles. Article 1, as a combination of probability of occurrence of harm. Magnitude of environmental impact must be measurable using objective criteria, considering harm to health, industry, property, and agriculture. Environmental damage varies by legal framework. ILC Draft Principles on Allocation of Loss, 2006. Includes personal injury, property damage, environmental impairment, restoration costs, and response costs. Nagoya Kuala Lumpur Supplementary Protocol, 2010. Damage must be measurable and impact biological diversity and human health. 1992 Civil Liability Convention on Oil Pollution. Covers contamination-related damage and restoration costs. UN Security Council Resolution 687, 1991, Iraq-Kuwait War. Iraq held liable for environmental destruction and resource depletion. Key elements of environmental responsibility. Article 6 of the draft articles requires prior authorization of activities posing significant risks. Preventive measures include environmental impact assessments, EIA, before authorizing hazardous activities. Duty to cooperate in good faith. Article 4. Duty to notify affected states about potential harm. Article 8. Duty to consult on risk mitigation. Article 9. Obligation to exchange information. Article 12. Public access to relevant environmental data. Article 13. Peaceful dispute resolution mechanisms. Article 19. Definition of environmental damage. Varied definitions across legal instruments. UNEP Report, 1996. Damage equals any measurable adverse impact on the environment, reducing its capacity to sustain life. ILC Draft Principles, 2006. Includes personal loss, cultural heritage damage, and environmental degradation. Nagoya Kuala Lumpur Protocol, 2010. Defines damage as significant adverse effects on biological diversity and human health. Oil Pollution Convention, 1992. Recognizes losses from contamination and reasonable restoration measures. UN Security Council Panel, Iraq War 1991. Expanded liability scope, including losses in agriculture, health, and ecological services. Conclusion. State responsibility and liability operate independently in environmental law. Key trend, shift towards preventive obligations rather than post-damage compensation. Challenges remain. Ambiguities in defining environmental damage. Differing state capacities to meet due diligence obligations. Conflicts between developed and developing nations on liability regimes. Future direction, strengthening global cooperation, financial security measures, and enforcement mechanisms to ensure accountability in transboundary environmental harm. Next. Page 15.7 The African Union and the Environment. Africa faces environmental challenges such as deforestation, desertification, biodiversity loss, climate change, and water pollution. These challenges are exacerbated by poverty, illiteracy, malnutrition, inadequate water supply, and poor health. The African Union, AU, was established in 2000 by the AU Constitutive Act to address political, socio-economic, and environmental challenges. AU objectives include Political and socio-economic integration. Promotion of human and people's rights. Promotion of sustainable development and cooperation in various fields. The AU and its predecessor, the Organization of African Unity, OAU, adopted legal instruments for environmental protection, forming the African Regional Environmental Law Framework. 15.7.1 Institutional aspects of the AU and environmental protection. The AU Assembly has adopted several environmental decisions, including a common continental position on climate change. Executive Council, Article 13, AU Constitutive Act, coordinates policies on environmental matters such as energy, mineral resources, and water resources. Delegates functions to specialized technical committees, STCs, including the Committee on Industry, Science, Technology, Energy, Natural Resources, and Environment. Article 14, AU Constitutive Act addresses environmental concerns like biosafety, ecosystem management, climate change adaptation, desertification, and resource management. However, decisions often lack substantial impact as they primarily endorse pre-existing initiatives. African Ministerial Conference on the Environment, UMSEN, Est. 1985 by UNEP. Advocates for environmental protection and is expected to become an AU specialized technical committee. Functions include environmental governance, treaty negotiations, and climate change response. New Partnership for Africa's Development, NPAD, 2001, established institutions such as the NPAD Secretariat, responsible for coordinating the NPAD Environment Action Plan, EAP, implementing sub-regional environmental action plans, SREAPs. 15.7.2 Sustainable Development in the African Union. NPAD serves as Africa's sustainable development blueprint, promoting peace and security, economic and political governance, regional development approaches. AU legal instruments affirm sustainable development. AU Constitutive Act, CAAU, includes sustainable development as a core objective. Abuja Treaty, Article 58(2). Mandates measures for sustainable development. African Convention on the Conservation of Nature and Natural Resources, 1968, First Regional Environmental Law. Revised in 2003 to integrate sustainable development principles. Covers land degradation, water resource conservation, species protection, conservation areas, and environmental protection during military conflicts. Establishes a Conference of the Parties, COP, as the decision-making body. Principles of the Revised African Convention, 2003. Align with Articles 22 and 24 of the African Charter on Human and People's Rights, Banjul Charter. Article 24, Banjul Charter, Right to a Satisfactory Environment. Serac Case, AU Commission interpreted Article 24 to impose environmental obligations on governments, including scientific monitoring of the environment, publishing environmental impact assessments, providing public access to environmental information, allowing public participation in environmental decisions. Protocol on the Rights of Women in Africa, 2003. Article 18, Right of Women to a Healthy, Sustainable Environment. Article 19, Right of Women to Sustainable Development. 15.7.3 Climate Change. Sub-Saharan Africa is highly vulnerable to climate change, impacting water access, agriculture, energy use, health, coastal zones, tourism, and biodiversity. Copenhagen Accord, 2009, recognizes Africa's vulnerability and prioritizes climate adaptation funding for the region. NPAD's Environmental Initiative, 2001, targets global warming through Climate Change and Natural Resource Management Program for Regional Adaptation Efforts. African Normative Framework and Climate Change. No explicit climate change regulation, but Banjul Charter, Article 24, can be used for environmental protection. Climate change obstructs sustainable development, making it an urgent issue for African states. AU response to climate change. 8th Ordinary AU Assembly, directed states to integrate climate change into development plans. 12th AU Assembly, 2009, approved the Algiers Declaration on Climate Change as Africa's common position. 13th AU Assembly established the Conference of African Heads of State on Climate Change, CAHOC, for international negotiations. African Ministerial Conference on the Environment, UMSEN, adopted the Nairobi Declaration, 2009, aligning Africa's climate position with the Bali Action Plan, adaptation, mitigation, finance, technology transfer. Nairobi Declaration asserts that an international climate regime must be inclusive, fair, and effective. African states use the common position in UNFCCC COP negotiations. Regional climate change initiatives. Climate for Development in Africa, CleanDev Africa, supports climate information use for policy. African Monitoring of the Environment for Sustainable Development, AMISD, uses satellites to monitor climate change. Great Green Wall Initiative combats desertification in the Sahel-Sahara. Disaster Risk Reduction Program. Paris Agreement. All 54 African states signed, most ratified and submitted nationally determined contributions, NDCs. Africa NDC Hub, 23 Colombian pesos, Bonn, established to support NDC implementation. 15.7.4 Sub-Regional Environmental Law, SADC. Southern African Development Community, SADC, promotes regional integration and environmental protection. SADC Treaty. Article 5.1, aims include sustainable natural resource use and environmental protection. Article 21.1, mandates cooperation on natural resources and the environment. Article 22, member states must conclude protocols for cooperation. SADC protocols cover watercourses, energy, mining, wildlife, fisheries, forests. Regional Indicative Strategic Development Plan, RISDP. Identifies environment and sustainable development as priority areas. Aims for equitable and sustainable use of resources for present and future generations. Challenges in implementation. Weak implementation of AU environmental law. Low political commitment to regional integration and environmental protection. Weak enforcement of legal frameworks despite progressive provisions. Next page. 15.8 Outlook and Future of International Environmental Law. Challenges and questions. Uncertainty about the adequacy of sustainable development in addressing global environmental crises. Lack of political will and commitment hinders effective global environmental protection. Slow progress in climate change negotiations, for example, COP meetings, raises concerns about future outcomes. Potential legal innovations. Intersection with human rights law. Growing recognition of environmental degradation as a human rights issue. Environmental security approach. Emerging legal framework that treats environmental degradation as a security threat. Research on innovative legal solutions is necessary to address these gaps. Core problem: sovereignty versus global cooperation. States' adherence to traditional sovereignty and national interests obstructs collective environmental action. The global environmental crisis demands legally binding and effectively implemented measures. Achieving universal cooperation remains a fundamental challenge in the 21st century.